Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. It's already been a morning. It's one of those days. Here we are. They're in court. They're waiting for the jury to come over. I hope everyone's doing well today. It is Wednesday, May 7th, and today is day 11th of this circus. I know there's kids watching me today, and so I don't want to curse, but what I'm going to say is the nicest thing that happened to me yesterday while we wait for the jury to come over is that somebody sent me something that was posted on Facebook in a Facebook group. And the post was this. It says, I can't put it up. I'll put it up after. It says, my 10-year-old daughter has been following the case closely. She's invested. I homeschool, so she's been getting her schoolwork done earlier than she ever has, just so she can watch Melanie Little's stream. LOL. Here are some texts she sent me from her room over the past few days. My favorite, the random pics of Jen McCabe she sent. Laughing emoji. I consider her watching this trial a great homeschool lesson. I'll allow it. That's hilarious. The text message chain between this mom, her name is Raina Joy. Hello, Raina Joy, if you're watching, and your 10-year-old daughter sounds like a genius. And that makes me so happy that kids who are 10 can see the injustice and can be interested enough in the injustice to care enough about it, to watch what's happening and to recognize what's happening. And these are our future leaders. And it just makes me so happy to see this. Just crazy. She says at one point, the 10-year-old to her mom, she says, the mom says, I think these texts are new. I wonder what's in them. And the daughter says, I can't wait to see. Is the sister evil too? Cross yet? Says the mom. No. And then she says, Mom, this guy said he didn't look around in the house, just with his eyes. And then she said, the mom said, horrible police work. And the daughter said, LOL, cross is on. And the mother said, oh yeah, AJ is smooth as butter. And then the 10-year-old daughter sent 4 butter emojis.
All right, thank you.
And that made my day. They're waiting for, oops, what did I just do? God save the Commonwealth. Raina Joy, your daughter seems like a joy herself. Shout out to you and to your daughter. Let's see what today brings. I'm still so mad about yesterday that I'm not even over my anger from yesterday to start my anger for today. The more I thought about Gallagher's testimony, the more I thought, wow, he's covering for his boss who lives across the street from Brian Albert. And you know that if that Arlo camera showed Karen Reed hitting John O'Keefe with her car, for sure they would have that video.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, hold an indebtum within and for the county of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
God
All right,
save
good
us
morning
from
again,
the Commonwealth of
Council.
Massachusetts.
Morning, jurors. I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Does he think that the louder he speaks, the more people are going to believe him? I believe Connor Keefe is the one who actually extracted Jen McCabe's phone, but we're going to find out. If I'm too loud, I'll lower my volume, but we have to wait until they find the mics.
Good morning, sir. Follow me. Now step up, raise your right hand. Thank you, clerk. Thank you.
Raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God? Yes.
I think every time a witness lies, they should fall into a burning pit of fire right underneath
All
the
right,
trap
Mr. Brennan,
door.
whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure. My name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the Academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the Homicide Unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Mhm.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with
Yes,
any
he
of the
was.
digital forensic evidence?
Yes.
Specifically regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
Oh, frickin'
After you
frack.
received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road
Tully
in Canton,
again.
Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role?
He's one of the mysterious people that showed up at the scene when the CERT team was there. Okay, that accounts for 1 out of the 5. Oh, including Tully. So now we still have 3 unidentified people.
In that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was
Tully's right.
had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
And why would you do that?
to secure it.
Wait a second.
How would you become aware if there was
They found evidence bags. They have evidence bags. They didn't have to dig through their trunk and find a Stop and Shop bag. Got it.
a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
See what they're doing here? Do you see
Right,
what they're
to begin,
doing?
I'd like to
They're trying now to create a chain of custody where no chain of custody logs ever existed before. So now he's found witnesses to come in and try and now, over 3 years later, and 1 year from the last persecution of Karen Reed, try and create this mystical chain of custody that has never existed before. Exactly what he's doing here.
show you on the screen a series of exhibits. If we could start with Exhibit 74, please.
I want to know something else too. We haven't seen anything. I didn't realize,
Do you rec-
or I forgot, that they extracted Kerry Roberts' phone. Have we ever seen anything from her phone? Have we seen any messages from Kerry Roberts' phone ever? Tell me.
recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Oh,
Did you see that item that night?
Yes.
74A, please.
is it a left shoe or a right shoe?
74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker,
Twitter is a buzz today, and it was a buzz about this about a year ago as well. If you look at the sole of this sneaker in this photograph, it looks like it has a black sole. The sneaker they held up in court last year when they took it out of the evidence bag had a white sole. I don't know what to make of it. There's been conflicting opinions about whether there's some kind of poor lighting that caused it to look like a black sole. It looks like a black sole to me. I'm hoping that since the last trial, the defense is aware of this, and that there's any way that this is not the right shoe, that perhaps they will bring it up this time. And so I just don't know what to make of it, but I'm just bringing it to your attention in case it comes up.
did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Not being like a big sneaker person, admittedly, I see a Nike swoosh on the outs on the what I'm looking at the size of this inverted sneaker. They called it an inverted sneaker yesterday. But to me, this looks like a left shoe. And so I'm asking you, my sneaker fans, does the swoosh only appear on the outside of the sneaker, meaning the outside of your foot, or is there also a swoosh on the inside of your foot? If anybody knows the answer to that, let me know. So now he's going to pull the sneaker out of the bag. So let's take a look. Yeah, they're minimizing Proctor's involvement, and they're right. And everything is Tully now. It's on both sides of the swoosh. Okay. So to me, that looked like a left shoe.
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
So many black souls, SOULS. I see what you did there, and it's great.
Let me ask you a few questions before you open it. Could you stand and show that
Yes, sir.
bag? There's red tape on it. What's that for?
To secure the bag closed.
They're securing
the
the bag.
Bag is open. Is it then retaped?
Yes,
Do you write on the outside of the bag?
yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
I mean, we can't say for sure because there's no other pictures of the sneaker at the scene other than the pictures of it against the curb. So. Oh, there are two pictures of it. The second one is white. Okay, thank you, Mighty Heidi. So that was a left sneaker for sure, right? Okay, so let's see.
Sorry.
I mean, this is hard to get into. This is locked up like Fort Knox now. I know, you can't even make this up. It's so crazy.
With the court's permission, can he show the item? to-
Yes.
Thank
I mean, does that shoe look brand new to you? Does it look like it just came out of a box? Did they clean this with like the magic
you.
eraser
So is that
before?
the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
I mean, that looks
Right,
like a
any
left shoe.
objections, Jen?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
So you're putting it in the the time on the bag is the time that you put it into the bag. What if it sits for 3 weeks in the back of someone's patrol car and then they put it in the bag? Do they put the date and time on the bag that they put it in the bag, or that it was actually found? I have questions.
Can the item be found before the time on that bag?
Yes,
Would you ever write a time later than when the item was found?
yes.
I'd like to move now to Exhibit 75, please.
Okay, are you going to tell us what time it says on the bag? Did they just skip over that part? This shoe look brand new. I it's not important that the
Preferably
times are accurate.
75A, please. Do you recognize that item?
Yes,
Is that one of the items you bagged that night?
yes.
And if we could turn to 76A, please.
Even a 10-year-old would tell you that the incompetent Canton PD would have been able to see giant pieces of red taillight in the morning when it was light out in less than 4 inches of snow. Even a 10-year-old could tell you that.
Do you recognize that item?
Yes,
Is that an item that you bagged that night?
yes,
Do you have both of those items with you?
yes, sir.
Could you produce those, please?
Let's see how big the
Skillman, you can
pieces
take that
are.
down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
The hat was not found until days later, I think. I'm not sure exactly. I don't remember exactly when, but it wasn't found at the nighttime search of the CERT team. Or during the nighttime search. Or did he not change his gloves? They make a big show out of it. Like, look what a great job we did. Look how great of a job we did. Cindy says, this guy struggles using scissors. I know. You can't make this up. Like the Keystone Cops. Really? Look how big those pieces are. In less than 4 inches of snow, do you think that even the incompetent, bumbling fools of the Canton PD with their leaf blower might have been able to see those? Or are we supposed to believe that they're really so incompetent, as fully evidenced yesterday and the day before by Gallagher's testimony, that they would never have seen that in a million years? Right. This was only found during the nighttime search. Giant pieces of taillight that
Sir,
were
on those
shattered by
items
a
that are
human
stickers,
arm.
did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you
The
know
Lego
if these
set.
items were ever sent to anybody other than your evidence locker?
They forgot to take the price tags off when they bought the Lego set, and they the pieces were like individually marked or something. I mean, this is the incompetence and the ridiculousness that we're dealing with here. A human arm shattered a taillight into pieces that big without breaking one bone in the human arm. But what had happened was the taillight shattered from hitting that arm into 47 magical, really sharp pieces that were like almost like dog's teeth, and all at the same exact time made marks onto John O'Keefe's arms, which you haven't seen yet if you're new, because they haven't shown the autopsy photos of his arm. But what also had happened was in the sweatshirt that John was wearing, there are no tears or rips or anything that looks like a slice from a knife. No, just puncture holes. Okay? This is like a mystery that we're solving before your very eyes because nobody else cared enough to solve it.
Were they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived
It
there?
magically appeared.
I do not.
Could you just pull out that other small piece and show the jury as well?
Did it break off from the other pieces? Because that's how careful they are with handling evidence, that it broke into another piece, maybe, he's going to say. There is just, hi, Ed. Oh, that's a little teeny weeny piece.
Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Oh, objection. Hey, he only put 2 pieces in, but now there's 3 pieces because it magically reproduced in there because it was very fertile. And as such, now there's 3 pieces. We don't really know how that happened, but I guess maybe they forgot to put bubble wrap in there with it. I don't know. I'm just spitballing here, just spitballing. They object to this coming into evidence, which is interesting because I think it came in last time. Somebody said that's the most important piece.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes.
You do that part, that secret part where we have to authenticate evidence.
Sir,
It's
on the
secret.
small chip piece, you don't know how it became chipped?
I do not.
I'd ask you
Objection.
to remove that chip.
Who says it chipped? Maybe somebody snuck another piece in there. Maybe it just revealed
I'd
itself.
like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
It's like a
And
magic
then I'd
trick.
like to introduce that exhibit.
No, because it's not in the same condition it was when he
So we're
collected it.
going to mark the little chip.
You
Ms.
would like to mark
Giannetti
it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope.
The world is watching. This
Thank you
is a
very much.
farce. The United States of America is supposed to have the best justice system in the world. And it's a joke. This is a joke.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please?
Do you believe in magic?
Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
Criminal mind. Oh no, it says criminal med, but you should be criminal mind. It says, was
Sir,
it in the
showing you a
bag?
photo, you recognize what's in it?
Meaning the third little tiny piece. Was it in the bag before the other two pieces went in the bag? Was it the bag they brought illicit evidence in? Did they bring pieces of taillight from the Sally Port to the scene? And were those pieces already in there? I mean, you can't even make this up, but that's a great, great theory. I'll allow it.
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
There's no objection, Mr. Yannetti?
There's no objection, no.
Oh, we're going to hear King David today on Cross. I love this for us.
79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
A little behind, so I'm going to give him some
Are
time.
these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Yes, yes. You see, the Canton PD was also so incompetent that they could not find these two pieces. But why did we only see a photograph of one piece? And now there are two pieces. Did they forget to bubble wrap that one piece and it broke into two? I have questions. Like the big reveal. Where evidence magically reveals itself. Canton, Massachusetts.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
Right.
This doesn't change his gloves, Ed.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yannetti?
Please, Your Honor, thank you.
Please.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes,
You also dated it February 2nd of 2022, correct?
correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Prayers up for Dina Jam's dad. Prayers up for you, Dina.
And I just ask you to read that silently and then look up at me when you're done, Trooper.
Thank you, Elizabeth.
Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay.
February 2nd was the day that Karen Reed was
I will not.
indicted. I mean, arraigned,
Exhibit 81.
hauled into court in front of all the TV cameras.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
The lead investigator is the trooper who is responsible for the case, correct?
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit
Not lying.
while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
you'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
Oh, really? This just got interesting.
If I may just have a moment, Your Honor.
Okay.
They give you a super sticker. Sorry, I don't remember my lies. They've been trying to walk away from Proctor and distance themselves from Proctor. And this kid is honest. He's not going to throw his career away. He's pretty young. I remember him testifying in the first trial.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach you on it?
Yes.
Did Proctor lie and say that this guy was with him when he interviewed Sarah Levinson? Did they ask Sarah Levinson who interviewed her? I don't recall that.
No, not at all.
Thank you, Arter Barak, who says, he just wanted to show you my support. I'm a mailman out of Worcester, but my fellow mailman watch your stream. I would also like to give a shout out to my buddy Chris, who I know is listening. Love you, big dog. He says, love you both. Thanks for tuning in. I'm happy to entertain you on your mail route. Just don't, this can cause road rage. I think we should put a blanket warning that listening to this trial while you're driving at work can cause road rage. Disclaimer. Thank you for your super chat.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
Happy anniversary, Trisha. She just donated $20 to Karen's Defense Fund in honor of her 20th anniversary. Please join us. The link is in the show notes below for the Defense Fund. Thanks, Trisha. That was sweet of you. I don't think he sounds or looks like Buchanan Tracy. Do you? Do you guys? Thanks, Tracy. Thanks, Alman. I love Auntie Deb. He's the best. You're very sweet. Best gun losing detective is here. That's a great name. You guys are the snark tank for a reason. Says these photos stink. Boy, Connor Keefe is really racking his memory now. Did I say I was with Proctor when he did this? But Proctor's been terminated. I still have a job. Am I going to lie for Proctor? I don't know. What should I do? Can you hear the internal conversation in his head right now as he ponders? Because we know this witness interview is not as long as it's taking it to read. Hello to the
Trooper
Netherlands.
Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
The internal monologue in his head right now about whether or not he's going to lie. Yeah, Handler, I'm fine. I just got stuck in traffic this morning and I hate being late. But thank you. Being late is one of my pet peeves. It really gives me a lot of stress. Side Bob Buffs and Rams fan says, shoe destroyed by Chloe. They got the soul wrong. I got questions about that hat. It was a very unique hat. It may have taken a while to find a dupe, in my opinion.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes.
Oh,
And
hold on. Do you think he's telling the truth? Hold on. Oh, the body language experts are going to have a field day with this. Hold on. I don't think he was there. Watch. Oh boy.
The specifics, but
so when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes.
Okay. And
Little side glance over to Brennan.
the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input. on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you.
I
if
don't
you
think he was
mind.
there.
May I approach Judge?
Yes.
You're welcome.
Do you think they've ever had a homicide investigation since? Oh, well, he has, because he's MSP. Forget it. He's not Canton PD. Never mind. I just think something's off. He didn't remember, and then he looked at the report. He looked at it for an awfully long time, and then he's like, do I have to say I was there? I guess I do. Otherwise, you know what's going to happen to me on the job. You know my gut. Raina Joy, ask your 10-year-old daughter what she thinks if she
Other
thinks he's
examples
lying.
are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
He remembered that part.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes.
My gut tells me that Proctor lied in the report saying that Connor was with him for the interview because they're supposed to do these interviews in pairs, and Connor really wasn't there. That's my gut. But I just don't know, Mimi. I don't know.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure.
I feel really bad for this kid. I mean, this is like, talk about the blue wall of silence. We're a little behind, but I gotta watch his body language. He's got a wedding ring on. Like, Connor, you seem like a nice boy. Don't risk it all for these SOBs. You saw what they did to
Again, read
Proctor.
that silently to yourself and look up at me when you're done.
I have secondhand uncomfortableness. Secondhand discomfort is what I have right now. Erin says there was no dirt on the bottom of those shoes. Yeah, well, it was inverted in the snow. Oh, thanks, good citizen. But I think another YouTuber, another law tuber actually, I think already uses the slogan, I have questions.
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that CF McCarthy's there, or is that waterfall?
This is CF McCarthy's.
Okay, I meant CF McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
What does he know about
Now,
that video from CF
Another member
McCarthy's?
of,
It seems like he said at least 3 times, I had nothing to do with analyzing that video. All I did was retrieve it. Why? What does he know about that video? Was that video proctored too? Maybe, in my opinion. Oh. It's palpable.
Your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
What's his nickname? What's DeChico's nickname? Okay. Here's the lore on DeChico. In the text message thread between Proctor, Fanning, and some of his other Buchanan, I forget who else was in the text message thread, DeChico and Kikowski, they were having a conversation about trying to get the medical examiner to change her manner of death from undetermined to homicide. And DeChico said in the thread, after Proctor said, we visited her 3 times. She's a whack job. She won't change it. Me and Yuri visited her 3 times or spoke to her 3 times. DeChico said, rookie move. You should have had me and Jeff do it. Jeff meaning Kikowski. So it seems like DeChico had a history of strong arming medical examiners to say what he wanted them to say. I want to know what his nickname was.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
He's the rookie.
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022.
Oh, he was at the
And
autopsy.
with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office
The medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
Former colleague.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Trying to get in the text messages that we were just talking about.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
Looking at Brennan.
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
We've never seen the autopsy report. It's never been made public. His cheeks are getting red. He's getting real thirsty.
May I approach, Your Honor?
Looking really uncomfortable. There's a hot mic and it said something sucks. All hail King David is right.
So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you.
Also, do you know who killed Enrique Delgado Garcia at the MSP Police Academy? during fight night? Because there's a lot of people not speaking up about that case too.
Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
He just not. He looked at Brennan and then nodded when he got the objection.
May we approach?
Object to this line of questioning. I don't know that I've ever seen a more uncomfortable witness, aside from Kurt Pfannenstiel, who was confronted with some text messages in the Dr. Harry Turk trial, which happened in this same exact courtroom. They're going to sidebar, so we're going to watch his body language again. I'm not a body language expert, but I have pretty good intuition.
Your understanding was that the cause and manner of death was still undetermined,
He looks at
correct?
Brennan.
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's
His
arms,
lips.
correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had
at his
seen the
mouth.
injuries to John O'Keefe's arm.
Eyes.
Object to the line of question.
He nodded.
May we approach?
Something's going on here.
Jurors, feel free to stand up.
Is something happening here? What it is ain't exactly clear, but something's going on here. And I think the Commonwealth has said they're not calling Irene Scorti-Bello, who is the medical examiner that did the autopsy. Hydrate, Bev. It's going to be one of those days.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing, just ask a different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And
She was
in
looking
order to
at
do
the
that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank
I'm not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
You could see a compound fracture
And
because
it
the
is
bone
common
sticks out of the skin.
practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none, thank you.
All right, you're all set, Trooper.
A lot of questions about the arm, a lot of questions about, and he was super uncomfortable.
So, jurors, this break we're going to take now?
Why do they need a break? Why is there going to be a break now?
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit
Oh, good.
longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so.
We did get coffee for you, so there's that. That in addition to your $15 a day that you're making for your service. Actually, I don't know how much they get paid. How much they get paid in Norfolk County for
So I
jury
want to
duty.
talk a little bit more. So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision.
What?
And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll
What
go
happened in
finish
Maryland?
reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Oh, yeah, I was there that day.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay.
Jessica Hyde a liar?
That's a shall.
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, the court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
I think they found something from Maryland that
CC for ID.
Okay.
could
Thank you.
preclude Jessica Hyde from
So-
testifying?
Assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
into the answer, Your Honor,
Let him
will
speak.
explain it. It's a very short answer.
Okay.
Maybe if you would let him speak, he would get to his point because he knows his point.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
If she's not asked about the 227, I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand.
You can't follow him? You know why?
Draw
I'm sorry.
some type.
I'm sorry. You know why you can't follow
Well-
him is because he is so much smarter than you are that you never in a million years could understand anything he's talking about. And they're paying you $1 million probably by the time this whole thing is over.
Relevant to materiality. There's not this here. Number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance to materiality. There's none.
You don't
none.
messy
This
with
is not
Alessi,
a
dude.
Announcement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp. We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was, the 227 timestamp would.
No, that was raised, but this
Because his credibility has never been at issue in another state,
was
Your Honor. because he's
problematic in
testified
Maryland.
before.
The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been advertised with regard to Apple source codes. And if I could, Your Honor.
Okay,
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing.
Mhm.
Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph.
She won't turn
It
to page
says
6.
the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross
Smack
her
it.
on. So in conclusion,
Smack it.
Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can
This-
see the plan to dehumanize.
Dehumanize somebody. This is the guy who tried to exclude ARCA by claiming that ARCA was biased and in collusion with the defense attorneys. Okay. Now he's claiming that that Mr. Alessi is trying to dehumanize Jessica Hyde. Wow. Talk about bloviating, hyperbolic. Here we go. Listen to this.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact,
know.
they
Let's-
called an expert.
Let's Daubertize her, like you just said. Let's Daubertize her. He just made up a whole new word. He likes to make up words like supposedly, hebatoba.
Themselves in the last case, who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled, to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution, invoking the client's rights has nothing to do with the analysis.
Invoking the Constitution as if it's some sort of witchcraft, which is an insult to witches, by the way. Invoking the Constitution as if it's some sort of evil spell. How dare you invoke the Constitution? Because here in Massachusetts, that's not the way we do things. We don't believe in the Constitution. Can you believe that he just said that? Her right to a fair trial is not important. It's all about the Commonwealth getting a fair trial. And if you ever had any doubt that that's what this is about, he'll tell you. Let's hear it again.
Opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible.
See, in another court, in another jurisdiction, wink, wink, say no more, judge, say no more. You know how we do it here in Massachusetts. This is Maryland. In another jurisdiction, maybe that would be okay, but not here in Massachusetts, judge. Know what I'm saying? The fix is in.
Unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
A different judge, hiding behind the shield of a different judge, because we know Judge Kim Jong-Knone under her eye. We're in the bubble here. We're in the bubble of Norfolk County. We are in the bubble of the courtroom of Judge Lady McBev. Don't let them hide under the shield of another judge, Your Honor. We know you're on our side all the time, in my opinion, maybe.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right, and Mr. Alessi, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases,
That's so sad.
and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around.
Right, because with Whiffin's opinion hanging out there, it wasn't really so clear about the 227 search, and so tons of reasonable doubt. And if the jury finds 227 happened, your case is over, which it should be anyway. And so now he's really going to fight. And yeah, isn't so much hypocrisy with the way that he treated Dr. Russell and Dr. Wolf the other day in voir dire. Thank you, Just Mimi Sue. That was a great point.
It. And again, this is something that is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. but not knowing the court's wisdom on whether I'll be entitled to
The
rebuttal.
court's
I do
wisdom
not want to lose the opportunity to address points that were made.
is the court's wisdom. Is that an oxymoron? I vote yes. I would put a poll up, but the court's wisdom. Oxymoron much. Everyone smash the like button while we're here so I don't have to turn off the fan.
In the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and
Hold on a second. I want to know about the court's wisdom again.
On whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
so I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds,
Okay, but then answer my question after your 10 seconds.
but I will.
She's so flippin' rude.
Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's
Right.
methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now,
Shield and a sword, shield and a sword. So you can't use it as a shield and a sword.
to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue.
Okay.
Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's
Yeah. And Your Honor, my point would be, that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are
Well,
putting
actually,
an issue
they're triggering all of us, the worldwide audience, in an emotional sense. But okay, I see what you're saying. Does anybody else feel triggered?
to the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right respectfully to cross-examine on the issue that they're putting in issue. And they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not
So-
raising it.
you can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one
She-
quick? May I, Mr. President?
I just want to know, is she here?
He is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here.
You could take a red eye,
Yeah,
Mr.
why don't you come
Jackson. Get the ARCA guys here tomorrow. Oh, but Mr. Brennan, do you think she'd be able to stay another night? I guess she's up next. She's gonna need a little more than a half hour. That was we're a little bit behind, so we can minimize this, and we have tons of questions and comments. So we have plenty of things to talk about. Half hour. Well, she must be sitting outside in the hallway, eh? See more doubt. Thank you so much for your very generous $100 super chat. Says thanks for the coverage and refreshing commentary. As a DC transplant with a Massachusetts bar license, I'm questioning whether I will renew my bar license in Massachusetts. That Brennan and Bev's kangaroo court operates with impunity to convict an innocent woman is reprehensible. Yes, it is. I don't know how much it costs to renew your license or whether it's worth it, but do you ever intend on practicing there again, I'd love to see this Herrera case. It's a state court case. Hey, if you're still listening, Seymour Doubt, and you have access to the Maryland court system, it's a state court case. I think it's called Maryland versus Herrera, and it has only to do with Jessica Hyde. I couldn't find it in a quick search, but if anybody has it, you can email it to me. My email is in the show notes. Thank you so much for your super generous super chat. I appreciate you so much. Nell said pumped up kicks for the playlist. Thanks for your super chat. I just put that in while we were waiting for you. It's there. We have a Karen Reed trial mixtape, and it's below. It is below in the show notes. You may have to close out of your chat to get to it, but it's good. It's there. It's got over 100 songs on it so far because we started it during the last trial, and I think in song lyrics. So we've been adding to it as we go. Paisley Chicken says, I missed most of yesterday's testimony. Sounds like there were a few doozies we'll need to watch on the weekend. Oh, yes. Oh, yes. Oh, yes. Gallagher's testimony. Mind-blowingly unbelievable. Kimberly says, day 2 of being in bed, icing, elevating with all my devices. Oh, I hope you're feeling better. Still have not made a single butt dial. Amazing. Free Karen Reed. Thank you, Kimberly. We hope you feel better soon. Stay ahead of the pain. Shannon, nothing but trouble. There was a trapdoor under the witness seat. They would fall into a cart that took them to the bone stripper. Oh, I love you too, Shannon. Thanks for being here. Thanks for your super chat. Exhibit 22-02184 7-5 shows 3 pieces from CERT, not 7, only 3 pictures. Thank you. Let's do the timeline again. Way over my head, and I'm not sure. 3 pieces from CERT, not 7, only 3 pictures. So the exhibit had 7 pieces in it. And that's from the first trial, I imagine. I'll dig into that later, maybe. Jackson Ivy, thanks for your 5. I think Jen and Carrie drove Karen back to John's and stayed behind to take their shoes off to find a replacement shoe of John's to plant. Wow. I've never thought of that. I like the way you guys are thinking. Armchair detectives. Deborah Hazlitt, thank you for your 20. Why does it feel like this trial is to 2 defense attorneys, one defending the McCabe's and Alberts and one to defend the Karen Reed? Well, if you were here the first time, it was like that too. It was almost like Lally had the ball the entire time and he was playing defense the entire time. Deborah says the Commonwealth is not trying to prove Karen Reed's guilt. They're defending the McCabe's and Alberts' innocence, blah, discussing yes. And we're watching this for the second time. And it's even worse. It's even worse than it was last time. And that's hard to believe, but it's true. Thanks for your 20. The Misadventures Book Mouse points out that the baseball cap that John was wearing was not found until February 3rd, which was the day after Karen Reed's arraignment. She was arrested February 1st, right? She had to spend the night in jail. She was arraigned on the 2nd. Sunflower Day says they testified yesterday. They found 7 pieces, not 5. Okay. I'm glad you guys are paying attention. I'm paying attention. I just have a lot of things going on here behind the scenes. K Kentucky Karen, there should be initials and date for every time it was opened at the lab, the last trial, etc. Yes, there should be on that evidence tape, the red duct tape. Although one witness said it could be blue, it could be red. I didn't really know. Dr. Russell's gasps. Says the sole is all white. Why were their shoelaces untied? I don't know. That's a great question. Maybe that's the condition in which it was found. The sole is all white. Some people say it's a shadow. Some people swear that the swoosh is only on the outside. Says just us for John O'Keefe. They framed Karen Reed. Some people said some models or some models of the shoe or designs of the shoe have them on both sides, inside and the outside. So I don't really know. Shelly, didn't they have the taillight put back together in the prior trial? Yeah, they did assemble it and they have pictures of it assembled. Did they take the light apart and put the pieces back in the evidence bags? I guess they must have, because that's the way they were originally found. GV, my mom is a medic in prison. I showed her Officer John O'Keefe's arm and asked her what she thought. She immediately said, rookie cop dog, and Chloe was a failed canine. There's been speculation that she was a failed canine. I don't know that that's ever been testified to or proven. And Garrett Wing, who will be testifying for the defense, told me when he came on my show that it is uncommon. It's not never, but uncommon for females to become police dogs or canines. And so I don't know, but I'm glad that your mom agrees that they're dog bites in any event. Thank you very much. I don't remember sorry, I don't remember my lies. Says, am I crazy? I saw 6 solo cups, but 2 cups looked like there was no blood. That's probably because the snow melted. There was snow in the cups with the blood, and they held liquid terrifically, according to Sergeant Gallagher or whatever he was, Lieutenant Gallagher. You're not crazy. It melted. Big Hoss, thanks for giving a membership. B Mello says the sole in the sneaker on the scene was black, but the one he pulled from the bag was white. That's odd. Remember, it was dark when they took those photos too. So I don't know. I can't explain it. David Johnson, can someone explain how the clear plastic piece is going to stay on its end for the snow to fall around it? Maybe they should have asked the weatherman that question, because he testified about a lot of things. That really, in my opinion, helped the defense. Showed how little snow was out there when everyone left the house. So they definitely would have seen John O'Keefe's 6'2" body, right? Thanks, David, for your super chat. Melissa, thanks for tuning in from Australia, says, I believe the hat and shoe were put out the front from the basement once everyone was gone, with time for them to be covered deep in hours of snowfall before they searched later that afternoon. Plan and narrative in motion. Interesting thought, Melissa. Thank you for that and for tuning in from Australia. I heard some buzz, excuse me, on Twitter also that people were saying, it's so ridiculous. Why would he have a glass with him if he ever went in the house? I don't know. I'm just spitballing here, but I guess maybe whatever came inside with him had to be outside with him upon his leaving. I don't know. Just a theory. Just spitballing. Sorry, I don't remember my lies. Says, I'm blown away from Jump. No one treated this as a crime scene. All I hear is why would I? Why Jen McCabe had a private talk while others were in the house. Yes, it's insane. You're here. You're in the Matrix, the Hunger Games, the Upside Down. Charles from South Africa. Can we see a diagram of the debris field of the bits of taillight and references to the body? Yeah. Remember Brennan talked about this whole debris field in a pretrial motion? Was it in his opening too? I don't recall now, but there's no diagram of the debris field because nobody ever made one. Unless Trooper Paul did it later in his reconstruction analysis, which would be totally speculative, but we'll save the good bits for later. Hello, just south of history. I have so much respect for you, Melanie. Thank you for your coverage. Also, I just prayed for your dad, Dina. Oh, that's very sweet of you. Thank you so much. Kelly, Spotify ad, please. Lies, lies, sweet little lies. Demon Jones, independent artist. Okay, I don't know that one. We have a lot of lies songs. We have the Fleetwood Mac version. We have the Thompson Twins version. Lion eyes. You can hide your lion eyes. We got a lot of lying ones on there. I'll check it out later. Thanks. Stephanie Flynn, my mom with severe dementia has better memory than all the witnesses that have testified in this whole case, including the first trial. I'm sorry about her dementia, but thanks for making me at least, I think that was supposed to be funny. So I'm going to take it as humor. And I know it's very difficult dealing with a parent with dementia. And my heart goes out to you, Stephanie, but thank you for your super chat. Big Boy says, Flossie, Jossie, I love you. Melanie, thanks for getting us through another trial. I'm here for it. Thank you for your super chat. Clarity, how do I join? Link, there's a link in the show notes below. For some reason, iPhones don't play well with YouTube. And so the join button doesn't show up apparently. It's easier if you're on a laptop, but I do have a link in the show notes below. You may have to close out the chat if you're on your phone. If you're on an iPhone, also, you have to use a Safari browser for some reason. I don't know. Because YouTube is owned by Google. That's why. Circle of Willis, I have quadriplegia. There are many amazing doctors who know what car accidents do to the human body that can testify. Why not call the 129 ER docs? They did last time. First of all, I'm very sorry if you were rendered quadriplegic because of a car accident. That's horrific. Hope you're doing okay. The ER doc who was going to testify for the Commonwealth, Dr. Justin Rice, he doesn't remember anything about what happened that day. However, the defense does have Dr. Marie Russell, who was an emergency room physician for over 30 years. Not only did she treat hundreds, if not 1,000 or more dog bites, but she also worked in a prison as the doctor. And so she did treat a lot of prisoners with canine wounds. They put her through, I think, 2 full days of voir dire because Brennan didn't think she was qualified, even though she was qualified to testify at the last trial. And she will be testifying for the defense here. Sandra P says, good afternoon, watching trial 2 with you as I was trial 1, but I can't stand all those lies anymore. Love your comments and pauses and guests. Thank you. Thank you, Sandra. It's hard. It's really hard to do this again for all of us, right? Are you feeling it? Chris, best investment is buying a monthly subscription to your channel. Oh, thank you. You're so sweet. Wouldn't watch this trial without you. Thanks to the laughs. Thank you for saying that. I appreciate you. Every day, we're getting a lot more views than usual. Pushing up on like the 200,000 per view stream, which is crazy. But there's always one person that comes in and complains about the commercials on replay. And to that I say, for $3 a week, you can get YouTube Premium with no commercials. Why wouldn't you do it? I don't have control over the commercials. But, there's one in every stream. I'm going to go watch somewhere else. Okay, go ahead. Everyone has commercials. I don't know what to tell you. Kelly, maybe just one honest person will speak up. Come on, buddy. Everything he was objected to, and he didn't have to answer it. And he was uncomfortable, Connor Keefe, very uncomfortable. Kelly says, Mel, do you think Hank has not mentioned Proctor because he's not planning on calling him and to try and make it seem like he didn't have much of a role? I think maybe. It would be not so smart to not try and get ahead of Proctor, though, and call him, get it all out there. Then the defense can still call him, but they wouldn't be able to cross-examine him. They're going to have to direct examine him, but it can be done. But I think you're right. They're completely trying to distance Proctor from anything here. Although Tully did have his hands in just about everything. Angelia Taylor, what a beautiful name. Oh man, I'm with you, Melanie. He's uncomfortable saying this. He's entered the dark side. It's about Connor Keefe. This is sad. I feel like I'm watching someone's career tank. Yeah. Yeah, I felt it. I don't know. I'm intuitive like that too. Hi, Jay. J-I-L. J-I-L says construction worker in Peabody, Mass. We're all listening to your stream. Shout out to your team in Peabody. Hey, guys. Hey, guys. Can you believe it? He says Karen is innocent. He or she. We all know it. Good. I'm glad you're watching. I hope you're not. Don't fall off any scaffolding. Yesterday, somebody said they almost fell off their scaffolding because I made them laugh. Please make sure you're using all the safety equipment. We don't want to have to call OSHA. And, thanks for listening, all of you guys doing the Lord's work out there. Appreciate you so much. The Goodmans are here and they've gifted a membership. And look at their little profile picture is of I went to Cancun with attorney Melanie Little merch. I love that. Expert architect. Watch him purposely hold the shoe. Ask him to put the picture up on the screen and ask him what color is the sole. Then put that sneaker back, pull that sneaker bat out of the bag. Case over. Well, again, I can't prove it. They didn't ask him what color the sole was, expert architect, but thank you. Tamara says he's not very good at hiding his feelings. Connor Keefe, he looks like his mind is going a million miles a minute. Amy in Arizona says, I didn't watch the first trial. I've heard several times it's raining men. I want in on the joke. Please. Thank you. Well, here's the lore. So Jennifer McCabe claims that when she was inside 34 Fairview on the night of the party, or the Blizzard party, she Googled, because it was a family joke, because one of her sisters drinks too much. And all her sisters, I think, were in the courtroom that day, except for Denise, the scrivener of the timeline. And she said, so I pulled up a video of It's Raining Men and showed it to, the kids at the party. And we joked about it because it's like an inside family joke. Well, every one of the witnesses, including Matt McCabe, has that talking point about this It's Raining Men video. And what's interesting about that is that when we looked earlier in the trial, they put up maybe it was Whiffen, and there was like a timestamp on that tab for the It's Raining Men search of the video. And the last time she had accessed it was, I think, January 27th, which means she didn't pull up that It's Raining Men video. And what an odd thing for her to remember and Matt McCabe to remember. right? So you guys tell me. I think if there's any more of the lore than that, let me know. But Jen McCabe and Matt McCabe absolutely testified to it. And there you go. All of AJ's nickels, $50 a day for jury duty is what they get paid. Thank you for that. That's more than I thought. Bianca gifted a membership. Thanks, Bianca. Heather said, Bev, it's Dr. Jekyll, not Dr. Hyde. LOL. Tiffany, good morning. Since John O'Keefe was found face down, what are they trying to say caused the cerebral injury? I thought it was the ground, which makes zero sense. Well, it wasn't clear. When she said, nobody's asked her about this, we just flipped him over. We heard that, right, on the 911 call. But I didn't, it's unclear. Did they try and was he found on his back and then they tried to roll him onto his side because they saw vomit in his throat and there was also vomit found in his boxers? I don't know. And you're saying you thought it was the ground. That they're saying it's the ground that caused the big gash in the back of his head and his skull to break, according to Hank Brennan. And we say, some of us say, perhaps something else happened because he had injuries to the front of his face as well. Classic boxer injuries to both eyes, both temples. There were some skull fractures in the front and also skull fractures in the back and that big gash. Perhaps, I don't know, just saying, right hook, left hook, on the side, smack, falls down, hits his head on something in the back, such as like a weight bench with, maybe a 2-inch metal thing that holds the weights. I don't know what that's called. And then perhaps he passed out. Perhaps he was incapacitated. Perhaps he started vomiting. The Commonwealth wants you to believe that he was hit at 12:31. They have some magic potion now that has changed the timeline to 12:31. But we heard Whiffen say that at 12:32, he manually locked his phone and used face recognition. Like, it doesn't make any sense. And we know Karen was home at 12:36 and attached to the Wi-Fi or connected to the Wi-Fi at One Meadows, which somebody said could have been from 300 feet away. So none of it makes sense. None of it makes sense. It's outrageous. It is. I can't make it make sense because it just doesn't. It just does. Something else happened. Something else happened. And it was not a car accident. Nefarious Kendra. Thanks for your super chat. Your coverage and commentary of this nefarious baloney is amazing. Snark and sass is so appreciated. Well, we try. Riri wants to know how to get vomit in your boxers. Well, if you're sitting up or standing up, you bend over to throw up. That'll be how, right? I'm just saying. In addition to all the blood stains down the front of the shirt, when Andrea Burkhart and I did a show together, one of the shows we did together, Andrea Burkhart, who's also a law tuber, and my deadhead friend that went to me with me to Vegas to see Dead and Company at the Sphere a couple of weeks ago, or whenever that was, I can't remember now. She's a boxer, and she said those are the classic. That's where the blood trail comes when you have a fractured nose and your nose gets broken in boxing and your nose starts bleeding all the way down the front of your shirt. She's like, I recognize the pattern. Aaron M. says that, Your Honor, invoking the Constitution in defense of the charges is just a dirty trick and we should not stand for it. Did I summarize Brennan well? You did. That was wonderful. Oh, Midnight Mike, thanks for gifting 5 memberships. You're a sweetheart. Like a Rock says, could it be that Alessi didn't cross Garino because he's going to appeal the horrible decision by Bev yesterday? Talk about an ambush. Please add Bob Seger like a rock to the playlist. Oh, well done. I know because they would not appeal during the trial and they would only be able to appeal in the event of a conviction. And we do not want to have a conviction here. And they also have the opportunity to call Garino on their case in chief, which they may do. So it's not over until it's over. Fear not. Alessi is the man. Side Bob Buffs and Rams fan. Oh, Skull Buffs. I love Alessi's passion. Shield and a sword, Ed. Yep. Yep. Jenna, thank you for your super sticker. This decision is Bev's bias litmus test. Go, Alessi. We'll see Jen's corrupt sofa. Well done on the username. Girl, well done. I see you. Cynthia 1880. Why does Alessi need permission from Bev on the questions? He has every right to ask Hyde. The question is he allowed to bring up this other case from Maryland in which it was apparently decided that she was not qualified to testify as an expert because I don't know if it was her methodology that was unreliable or she didn't have the proper qualifications. And without reading the case specifically, I can't really give you a better answer than that. But he would need permission to bring up this other issue in Maryland to be able to cross her and impeach her credibility. She's the gatekeeper to the gates of hell, and we're all here under her eye. Thank you for your super chat, Shannon. So this may have been discussed, but they moved Paul to the back, and now Peggy is staring at Karen. No, I didn't notice that. They don't show the bench that much. I don't know why Paul was told that he had to sit in the back row. I don't know if he was told. And so we really don't know what went on in court that day when everyone was forced to leave the second floor of the courthouse and the judge met with only the attorneys for both sides and the families of both sides. We don't know what happened. And I don't know. Peggy's also staring at the jury, which I don't like. I don't like the setup of this courtroom. But think about this. In the big courtroom, the reason that Karen's attorneys moved to move it to this smaller courtroom is because in the big courtroom where they did jury selection, this courthouse is at least 100 years old. Sacco and Vanzetti were tried there in the 20s. In the big courtroom, the way the jury box is situated, half the jury is looking at the back of the witness's head. Imagine if we couldn't see Connor Keefe's face when he was testifying and we only saw the back of his head. Ridiculous. The judge was like, oh, it's the way we've done it for 100 years. No one's ever complained. And Jackson said, I don't care how it's been done for 100 years, Your Honor. It's wrong and it shouldn't be done that way. And so they did move to this smaller courtroom, and that's the trade-off. Thank you. Pressure Test Me for your super sticker from Australia. Proctor's dishonorable discharge just rounded up 18,000 head buckets. Smash the like button, everyone. Thank you for tuning in from Canada. Marilyn says, I love a smart man. Alessi, tell him bang, bang. Thanks, Marilyn. Jenna, I've been saying this for a while and could be wrong. Are the feds watching the second trial unfold for the plethora of evidence of corruption and bias? Well, I couldn't tell you why they're watching, but my gut says they're watching. I think they're watching. It takes the feds a long time. It takes them a long time to make a move. And by the time Matthew Farwell was arrested for the murder of Sandra Birchmore, it was 3 years. It was a little over 3 years, right? So I think they're watching, Jenna. Pinky, Alessi has his buttons and suspenders on today. It's so funny. Thanks, Pinky. Kathy's Crafty Life. Melanie, can you please give a brief overview of how Jackson, Little, and Alessi joined the defense team? It just started with Yannetti, right? Yes. Yannetti's local. My understanding is that Karen contacted him, I think, the day of the 29th. In fact, Lally wanted to bring it in last trial that her evidence that she called a lawyer on the 29th of January went to consciousness of guilt. And the judge actually said no. So Yannetti was the first to join the team. Alan Jackson and his partner, she's now a partner, Elizabeth Little, were brought in. I don't remember when. Chat, do you remember when? He's from LA. He was the prosecutor who prosecuted Phil Spector. He's also defended Kevin Spacey on his case that he had there in Massachusetts on the Cape, right? So I don't think that Alan and Eliza became involved until, I want to say, the fall of 2022. You know what? I could look at the docket, and it would say when September 2022, my father's keeper. Thanks. That's what I thought. That's when they applied for their pro hoc status, September of 2022. And then Alessi is a New York attorney. I don't know how he became involved, but he is also working for free, pro bono. He became involved in between the first trial and the second trial. He's a New York litigator, very high end. I think he bills upwards of $1,800 an hour. His whole expertise is experts. And as you can see, he does it, and he does it very well. And he fiercely believes in Karen's innocence, and that's why he's doing it for free. He works for a big white shoe firm. I don't know how big it is, actually. Hank Brennan, on the other hand, defended Whitey Bulger. He's a defense attorney by trade, and he was hired by Norfolk County DA's office to specifically try this case because they needed a hired gun because nobody else would touch it. Thanks for your super chat. Karen Duffy. Do you remember a cartoon called Danger Mouse? His sidekick, Penfold the Mole, is the absolute spit of Brennan. Okay, no, but I'm going to have to Google it because on my thumbnail today, I just have that weasel that I put behind him, like peeking over his shoulder, like the weasel is photobombing, because that reminds me kind of him. And that's what Canva had available. But I will look up Penfold the Mole. Penfold the Mole. Thank you. Private info. Thank you so much for your $50 super chat. Just joining. Work's been busy. Did I miss anything good? Morning, everyone. Yeah, you got to go back and watch Connor Keefe's testimony. It's not very long, but our spidey senses were up, and we think that he may have been afraid, and he may have been not quite telling us the whole truth and nothing but the truth. So help him, whatever God he believes in. But we're on break again, so. Carmel, thanks for giving a membership. You're awesome. Mustard Sandwich says Chloe acts like a rookie cop dog because BA probably attempted to train her like one, but didn't really have a clue, and now she has behavioral problems. Could be. Thanks for your super chat. J-Lo 5. How did no one, including Lucky, drive over all the tail pieces? The taillight pieces, yeah. How did no one at 34 Fairview ever find a taillight piece? How did it take weeks and weeks and weeks for all the evidence to just reveal itself, including Chief Berkowitz, who is now 6 feet under, driving by one day when he's on medical leave and just happened to spot a piece on the lawn, called it in, had some people collect it. It's insane. You couldn't make it up, and yet here we are for the second time. Thank you, Ms. Bouquet, for your super sticker. I appreciate you. The 34 correct view. Blower video shows footsteps covered in fresher snow leading up past the flagpole towards the house. Well, that's interesting. There's also a gate to the left of the house, like a double door gate, very large one that you could probably, if you had a boat, you could drive a car back there. Like it's like double doors to the left of the house. And so, just so you know, during the first trial, we saw a video coming because the new owners must have let the defense team into the house with a videographer, because there's a video coming out of the bulkhead doors from the basement, coming up the basement bulkhead stairs into the yard, then panning around to those gates I was just telling you about and to the flagpole. Strong leg, 1971. If Hank knew how to choose reliable experts, Alessi wouldn't have to argue their reliability and credibility. Yeah. Farmer says nefarious playlist. Is there a song named Nefarious? Is that what you're saying? Or you just think the playlist is nefarious? Sandy, is this case about a car accident? Asking for a friend. Yeah. Happened last trial too. Last trial was a different order of witnesses. The caption's picking things up, but there must be a hot mic because the sound is not up. I think last trial was, it was painful because Lally said, what if anything, what if anyone, who if anyone was driving the ambulance? He actually asked that to the ambulance driver or one of the ambulance person, who if anyone was driving the ambulance? It went on for 9 weeks before even the car accident was, I think, it's insane. It's insane. How did that jackhole get in here? Hold on. Do we have no mods? Mark Bedwetero. What a hack you are. What an absolute hack you are on Twitter and everywhere else. It is about a car accident, allegedly, according to the Commonwealth, but there was no car accident. There was no car accident. So tell your friend, a car did not hit John O'Keefe, and John O'Keefe was not hit by a car. And by the way, Mark Bedwetero, we know who you are. Guide your actions accordingly. Azaren Fish became a YouTube member. Welcome. Anne-Marie Alessi says it's all a big fat trigger. It is. Everything's triggering about this. Wojo's Mojo. Thanks for your 5. In honor of King David, I suggest for the playlist Tom Petty, It's Good to Be King. Oh, that's a good one. I like that song. I put my fall protection PPE on because this is riveting. Safety first. Yes, please. Safety first. Absolutely. Gives you hell is on there. It's on there. J Fooder 1 by All American Rejects. That's been on there for a long time. I love that song, and it's on there. Bullfrog 61. John's laces were untied because he always took his shoes off when entering the houses. He went into 34 Fairview, right? Where are the socks? Where are the socks that may or may not have dog hair on them? You know what's probably the funniest part about Mark Bedwetero getting in the chat is that he had to wait 48 hours to even chat. Such patience. Wow. Yes, I agree. Maybe that could be true. Absolutely. That may have been why it was untied. Tony and Sheila Catrone are here, and they thank you for your 20. I appreciate you guys so much. Teresa B. Hank Brennan is yelling because the jury is excited to hear AJ and takes notes furiously. And when Hank Brennan is up, they zone out. So he started yelling to get their attention. Could be. Kelly, did the FBI confirm that the 227 search happened? If yes, why can't they have the FBI specialist testify? Well, you saw what trouble they had getting ARCA in, and they've already got their own witnesses, their own experts to say that. So, with Brennan fighting everything, they're better off sticking with the experts they already have. But that's a great point, Kelly. Cannoni's disproportionate disdain. Proctor showed reconstructed taillight right behind Tully. Showed same loose pieces from the original search. January 29th. Been screaming about this since 1.0. Right behind Tully. Showed same loose pieces from the original search. January 29th. Been screaming about this since trial 1. If anybody can interpret that for me or comment back to Cannoni's disproportionate disdain to validate, that'd be great. Norman, thanks for spending your day with all of us. Well, thank you. Thanks for having me. Sound still isn't up. Thanks, Norman. Thank you, Zudi Harris, for your Zoom sticker. Lieutenant Leaf Blower. My leaf blower worked there terrifically. Yes, it did. It was terrific. Terrifically. Lauren Wilson, thank you for your super sticker. Melanie M, thank you for your super sticker. A lot of Melanies in this chat. It's big Gen X her name. Brent, thank you for loving my commentary and thank you for your super chat. Beetlejuice Breenan is here from Australia and says that young cop was lying, talking about Connor Keefe. No cop ever forgets attending your first postmortem. Thank you. The sight and smell alone remain in your head forever. My first was in 1998. Horrific to be subjected to. Oh, thank you. Thank you so much. Free Karen Reed, she says. I was thinking the same thing. Wouldn't you remember your first autopsy? Wouldn't it be something that you would never forget? Thank you for your continued interest in this case. From Australia. Love and thoughts to Karen and family, says Carmel. Thank you. New Hampshire dude is here and he gifted 5 memberships. Thanks, dude. Thanks, dude. I mean, I see captions, but I hear nothing. RW says Suspicious Minds by Elvis. Yes, it's on there. Melanie, love your wit and insight. Laughter is the best medicine. Thank you. Free Karen Reed. Genevieve 127. Paul Gallagher has 1 brain cell, a cold heart, and no spine. Watching him testify was testing me. Love you. I love you too. Couldn't watch it with anybody else. Thank you for being here. I don't remember my lies. Says, I'm adding to comment about John's untied sneaker. To me, this is important if John wore his sneakers untied or tied. Maybe they untied his sneakers to get them off John. I do not know. But I like the way you're thinking. Thank you, Michelle. And all these things that you're pointing out, all are what? Reasonable doubt. The attorneys were only allotted 1 hour last trial for closings, and it's nowhere near enough time. They need more time. They need to hammer home reasonable doubt, because if the jury is sitting in the jury room trying to figure out any other way that this could have happened other than Karen Reed hitting John O'Keefe with her car, that is the definition of reasonable doubt. We all go home. Jennifer says, the McCabe's and Alberts disgust me. everything comes back. Keep an eye on the future generations and see what I mean. Yeah, thank you. If that was not necessarily defamatory, but if you put up a super chat, not you, but anyone in general, and it's defamatory or something that's inappropriate, I'm just not going to put it on the screen, just so you know. TG from SB, thanks for the 5 new members. Just figured out how to join. Congratulations and welcome. Longtime subscriber. The lyrics "It's Raining Men" have been changed to "We're Framing Karen." Good job. I don't need a badge. Says so. A 200-pound John O'Keefe hit by SUV at 24 miles an hour, lost his shoes. Oh, just one. Flew back 12 feet. Well, it was 30 in the first trial. And now we don't even know how far it was because nobody measured anything. And remember, was it the weatherman who was measuring things with his thumb, from his knuckle to his thumb? Was that an inch? I can't recall. But still held on to his drink. Yep. First thing I'm thinking about, idiotic theory. Yeah. Yeah. And, you know, they played that clip of Karen yesterday saying that John took my full vodka and soda from the center console. Was that the glass that it was in? Or did he bring that one in? Because in her police interview, the only one that she gave to Proctor and Buchanan when they came to seize her phone and car at her parents' house in Dighton on the 29th, she said that she was drinking like vodka soda out of a vase style glass. That was a rocks glass. Clearly, the base of that was a rock glass. So I have so many questions. And that is only one of them. But also, if he went in the house with a glass, you could be sure that if somebody was going to put him back outside, they'd put him back outside with everything he brought with him. Shoes, phone. I don't know. Shisha. Doctor who did the autopsy is on the defense witness list, yes. And also on the combined witness list. That's Irene, Dr. Irene Scordy Bello. Pink Jemmy. What is with this break? I just don't understand how all those injuries could have happened with her reversing into him with her car. How fast was she reversing? They say she was reversing at 24.2 miles an hour. Try it sometime. Actually, don't try it. Don't try it. People have tried it. It's virtually impossible unless you're like Mario Andretti. When I'm backing out of my driveway and my foot's not even on the gas, basically just take my foot off the brake and I get up to 4 miles an hour, it starts beeping and warning me. They say 24.2 miles an hour, 60 feet in reverse. Nobody heard anything. Nobody saw the body, even though 11 people left after this alleged accident. And the Ring camera right across the street. Oh, sorry, Arlo camera. I never heard of Arlo before. At Tom Kelleher's house, the deputy chief of Canton PD, Gallagher knew his camera wouldn't have seen anything because Gallagher knew exactly where Kelleher's camera pointed. Let me ask you a question. Did it have audio? Would it have heard a crash? Would it have ever heard screeching tires? You can bet your bottom dollar. There's a 10-year-old listening. Hey, Raina Joy's daughter. You can bet your bottom dollar that the Arlo video of Tom Kelleher, had it picked up sound or video from a motor vehicle accident, they would absolutely have it. And it would have. And there's a more reasonable doubt, right? I hope they call him to the stand this time. Nina TN fan, AJ and KR smirking, saying, "That a boy, Alessi." Thanks, Nina. World turned upside down by Coldplay. All right, Midnight Mike, well done. I have my favorites. Tammy's cousin says, Larry Foreman showed me your channel for Daily Karen Retrial. Have you seen his short with Brennan and Bev nod head and shake no when Allie McCabe was on the stand? Well, Allie McCabe has not been on the stand this trial. Are you talking about Jen McCabe or are you talking about during the ARCA witnesses testimony? We've looked at a couple of those clips. It wasn't loud.
Enter your participant. Please enter the pass.
It's hard to say with
You
one
have joined the
little
meeting
camera
as
angle
an
like that.
attendee and will be muted throughout the meeting.
I don't know what they were doing, but it looks
Did you
sus.
see the quarters in
The
session?
host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience.
She did some research, but before we get there, Latina Gra, thank you for your 50. Please notice how yesterday O'Hara kept looking down, yep, and moving the blazer sleeves. Yes, I think he had notes from the previous testimony. We know the Canton PD, Brennan and DA would do anything to win this case. Please let the defense know. We pointed it out constantly yesterday. Constantly. We thought he was looking at his watch or his phone, but he definitely was looking down a lot. He wouldn't need to. I don't know about notes. I don't know. They could have been on his phone. Yeah, you're right. I'm sure they noticed it. I'm sure 100% they noticed it. And it was pointed out to them. I'm sure that somebody pointed it out to them. But thank you so much for your 50. You're super generous. Appreciate you.
So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so, upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding
Expense and delay? You want to talk about expense and delay? And you're being, look what it says right here. That decision, the captions mocked, M-O-C-K-E-D. That decision mocked for identification. You're talking about expense and delay. You had Dr. Marie Russell fly in from California twice to undergo full day voir dires. The expense of that for Karen. She flew an expert from Phoenix to Canton PD to get footage that was no longer there. They made a motion for those expenses and you said no. The voir dire that you just made the crash daddies come in from Pittsburgh for. You want to talk about expense and delay? The Commonwealth apparently has an unlimited budget because they're paying your boy Brennan $250,000 to start. And it's going to get up to $1 million before this trial is over. And you will not let Mr. Alessi impeach Jessica Hyde's reliability and credibility based on a Maryland court decision. You're an embarrassment to the bench. You're an embarrassment. This is a joke. The fix is in, and I'm done here. I am done with you people. This is outrageous.
her methodology. So that's my decision. So bring the jurors in, please.
Wow. If you didn't
You are unmuted.
think the fix was in before, here it is. There's your proof. It's not allowed. She can't be impeached. I heard she's been called to the stand, so I fast forwarded it. No, she just said it's not allowed. When did she say it's allowed? She just said it's not allowed. Did she reverse herself after that?
Muted.
Purpose and construction. Also looking to Commonwealth 17, that decision marked for, please.
Oh, when you're,
You are unmuted.
Apology. So that's my decision. Court previously. I'm excluding that decision. Your rights are saved, Mr.
She's
Alessi. We've
excluding
got
it.
that
Why are you
decision
saying she
marked
allowed
for
it?
identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology.
her
So-
methodology. You can cross-examine her with her methodology. You can't bring up the case in Maryland where she was found to be not credible and unreliable. I'm looking at the chat and thinking that I'm crazy. No, he cannot bring up the Maryland decision. I'm going to let you listen to it again.
Notice to the court previously.
He's saying you didn't give me enough notice and, expense and delay. And so I'm not going to allow you to bring in that Maryland decision.
Excluding that decision. Your rights are saved, Mr. Alessi.
Saved for appeal. Your rights are saved for appeal.
See, we've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology.
Right, but he can't bring up the fact that in Maryland, she was found to be not credible or reliable in the exact methodology and nonsense about location data that she was found to be discredited in Maryland for. No, please don't be confused. I am saying what is happening. She will not allow him to talk about the Maryland decision where she was found to be not credible and unreliable. He can cross-examine her, she says. That's his remedy. And his rights are preserved for appeal. Right? In case there's a conviction, then they can appeal. Okay? Thank you.
Follow me, please.
So the defense just lost that motion because the fix is in.
You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm
review,
so sorry.
what does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. in local time here in Norfolk on January 29th, 2022 from the device.
That's 2:27.
Not the device, forensic
Not
image,
2:29.
for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2/27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched.
Oh, was my mic on?
Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone.
Like
using a tool called
I'm sorry,
EXIF tool.
can a PDF be altered? So she didn't get the physical phone. She just got a PDF of an extraction report. Okay. Gotcha. Correct me if I'm wrong, chat.
I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF.
That's such a great question. Is he bleeding? How does this prove that Karen hit Sean? It doesn't. This is in defense of Jennifer McCabe. This entire expert is hired to defend Jennifer McCabe. Because if Jennifer McCabe's phone searched Hosslong to dying cold at 2:27 a.m., that leads to consciousness of guilt on the part of Jennifer McCabe. And that's a problem for somebody in the Commonwealth who wants to protect Jennifer McCabe. But I would submit to you that even if she didn't search it at 2:27 a.m. and searched it in the morning, nobody other than Jennifer McCabe says that Karen told her to search it, other than Jennifer McCabe, because Kerry Roberts lied to the grand jury, and that could still show consciousness of guilt on behalf of Jennifer McCabe for searching that. See?
It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, Are you able to tell whether or not there's been any alterations or tampering before the item is put on the gray key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that
Yes.
correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it
Thank
being
you.
imaged. I can only validate if the
Thank you
image
so
was
much.
correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes.
Everyone
At the
all
time
together.
the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search,
Tell
and
that funny
any
story
alleged
after.
deletions of phone calls, I
Remind
want to
me.
start with you, your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27.
Oh,
There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports.
Hockomock.
Looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab actually.
So Haas Long to Die in Cold was done at 2:27. Did she just say that? That kind of sounds like what she just said. Hold on.
And you go to your browser, was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. And that search was done there.
That search was done there. It's not clear whether she's referring to Haas Long to Die in Cold or Hockomock Sports. Okay, so I use the same Google tab to search everything all the time. So are you telling me that when I search something today, it's going to revert back to the first time I opened that tab 3 years ago? I call.
Another tab actually at 2:27 was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that's browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's
When
active.
did she search It's Raining Men?
And that tab, the last search done in that tab is How's Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Okay, so last year when I went to court, I remember it was June 14th, Mark Better and I went together. This was the day that the Jessica Hyde's first day of testimony, her only day of testimony, I guess, from that day. What had happened was a juror got called up to sidebar, and the camera person from the pool camera caught the juror on camera by mistake.
I do. This is table 1 from the first report I created on this case.
Judge forced them to shut off cameras for the rest of the day or the rest of the morning. And what had happened was they got like a Zoom camera underneath Jessica Hyde's chin, like right where the microphone is on the base there. And everyone had a very unfortunate view of the Zoom camera pointing upwards at her chin. It was the most unflattering angle that any woman or anybody would ever want to have. And she had to testify that way last trial. So I guess they're doing her a little bit better with the camera angle, but you know.
Case on the phone that I was told was for table 1 from.
Piece of paper, do you recognize that?
Do you guys
I
remember
do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Please do. Please approach. Thank you. She did wear a head wrap last time. Let's not, we don't need any anti-religious comments in the chat or any comments about her appearance. Let's talk about her credibility and her testimony, okay? You guys are better than that. When I went to fill up my drink, I saw some things in the chat that were kind of beneath you. If you know, you know. And I know that you know, because you do know. You know how to keep it classy.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just ask you?
See if you can answer the questions and if you can let us know.
Yes, Your Honor.
Sounded that to me that she said it was done.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search How's Long to Die in Cold?
Correct. I was looking for 2 searches, both How Long to Die in CIKD and How's Long to Die in Cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was.
I'm sorry. Do you want to interrupt the whole class so that I can address your comment that I talk about Lally's baby shark all day? That's different than disparaging someone's religion and body shaming, as far as I'm concerned. He wears a funny hairdo. So if I need to explain that to you, give me a break.
The application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used Artex and Mushy. But the, I'm sorry, Artex is capital A, lowercase RT, capital E, lowercase x, and then Mushy.
It's another infomercial for Ian Whiffen, who created Artex. They're friends, I think. I think they found one through the other. I think they found Jessica Hyde through Whiffen. Is that right? Am I remembering that right?
Is M-U-S-H-Y.
Moofy.
You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrate tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
there are actually multiple artifacts for how's long to die in cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that how's long to die in cold. Only one of them is associated with the 227 timestamp, but there are other instances
Interesting.
of evidence of that was parsed by Celebrate.
Sounds to me like
Is there
she's
any
searching at
danger for an
227.
untrained eye to rely simply on the software when looking at a search like this, how long to die in the cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or...
Implicate is a good word to use here, because if that 227 search was done, it sure does implicate someone other than Karen Reed. And yeah, it is really scary. Everything's really scary about this 227 search, isn't it? Glad you're putting out all the buzzwords there that help the defense. Thank you for that.
or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Concern,
Yes,
grave concern.
I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University and their digital forensics master's program,
She's trying to teach the jury.
in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
They're putting her up against Richard Green, who has decades of experience. She seems very young. She seems very nice. I'm sure she's a good teacher, but she does not have more experience than Richard Green.
You mentioned that Celebrite showed the search on the report as how's long to die in the cold with the timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
And it was specifically because of Jennifer McCabe's search, wasn't it? Because that's what he even Whiffen said. It was only in this case and one other worldwide user in Germany had this problem with the timestamp. And because of that, this company decided to change their software, take the timestamp away. Follow the money. Who do you think their biggest clients are? Law enforcement. Hello, prisoners. Are you watching? Can you watch YouTube from prison if you're out there? Hey, what's up? Listen, all of you who are convicted on Celebrite searches, you may want to call your lawyer or your jailhouse lawyer, because you guys have got time. You spend a lot of time in the law library there. You may want to open up your case for an appeal based on Celebrite if you were convicted because of it. Just a hot tip, not legal advice at all.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions,
Yes.
tab sessions.
Thank you, John.
But the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to
May the Lord open.
talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp.
Eric Carney is here and says, does she parse and carve bullcrap all day? Yes. And how dare you? How dare you?
Phrase, how's long to die in the cold? Where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as—
She looked it up. She looked it up in the manual. Don't worry. We got the right info. She never looked at the phone. She wasn't given the phone. She was given a PDF from Norfolk County DA's office. And I think Tully is the one who reached out to her on her website and said, hey, can you be our expert? She was like, sure, no big whoop. What you got?
which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when the search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms
How much cash are they
for
paying you
commonly
for this?
searched
You
items.
dribble.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking
Corn has
information.
entered the
You may
chat.
intentionally use a private browser. For Google users, this would be the equivalent of
Or maybe they're on Ashley Madison or Tinder or something and they're cheating and they use Signal and they also, use WhatsApp and, incognito mode, Jess. They call it incognito mode.
incognito in Google Chrome.
Oh, thank
And
you.
you may, Google users, this would be the equivalent of incognito in Google Chrome. And you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches and some exist for
I know what she said, but
private
we have to
searches.
call it
And in
corn.
this
just
case,
for
this
YouTube
phone, was it
purposes.
on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden.
I don't understand the question yet.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct.
she
So I
get the
believe the
chart?
next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you
Show her the
saw
chat.
that, do you look on the same tab or a database?
Hanky, show her the chat. Here's the thing about YouTube, you guys. If we say instead of corn, the word that they actually said, and it's in the chat, then YouTube thinks we're promoting that thing. And then they have AI that goes through the chat and they, give you the big red dollar sign, which nobody wants. So that's why we got to say that for people who are confused.
Where do you find that information?
Fair.
That, however, was an excellent freeze frame. I can't get back there right now, but you'll enjoy that later.
Understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those. And I was looking in the entirety of the scope
accent.
from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for Browser State DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see is we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been
I feel
how long to
I can't talk over her, but I just want to say a lot of us have watched both trials, so we know what they're getting at with this 227 search. But does the jury understand any of this at all? Do they understand why there's an argument about this? Do they understand that Jennifer McCabe was kind of asked about it, right? But we still don't really know. Like, they must be so confused. And if you're watching this trial for the first time, please tell me if you're confused, because I know what they're talking about because I've seen this film before and I didn't like the ending. So now I'm here for the first sequel, and I hope the ending is better. But do you think they know what she's talking about?
Die in CIKD, CIKLD, CIKD, CIKD.
And
Sorry.
finally, at 6/24/47, did you identify any artifacts with that search that appears with the timestamp of 2/27/40? Did you find the same?
Correct. At 6:24, we have 2 timestamps in the same 2 locations for Hoslong to die in cold.
Because she had to spell it the same way
knowledge
she
C
spelled
and
the
the mobile
first
safari
time,
plus.
so she could
So
make it look
based
like
on
she
your
typed
analysis
627. Duh.
in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did
she
you
didn't
come
examine
to
the
an
phone.
opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
She winked at him.
Rephrase the question as
She just winked at him. Look, when he got the question right, she winked. Come back to your screen if you're not driving or on scaffolding, or you don't have a jackhammer in your hand or a nail gun. Watch.
At that timestamp tab of 2:27:40.
Yes, I came to an opinion.
And what is your opinion?
rephrase the question as to the opinion.
I'm sorry?
I'm
I'll see
sorry?
you at sidewalks from Mr. Alessi.
You have an opinion with a reasonable degree of forensic scientific certainty. That's the question, Mr. Brennan. Would you like me to script it for you? Pierogi Cacciatore. Great catchy name. I guess you're are pierogies Polish? Polish and Italian. Pierogi Cacciatore says the most honest witness so far has been Heather Maxon. Love me some Heather Maxon. Heather Maxon is a goddess as far as I'm concerned. Do you think it was awkward for her to have to hang out like in the hallway with Ryan Nagel since they were exes like 3 years ago? I mean, they could be like married to other people now. I wonder if they had a bad breakup. I wonder if they broke up because of this case. I wonder a lot of things about the relationship of Heather and Ryan, why they didn't work out. Although that is not the thing about this case that keeps me awake at night. I do just wonder, but I do love Heather Maxon, I will say. She's a beauty. Yeah, she's a beauty. Somebody just said the same exact thing that you guys say all the time, that I say what you're thinking. You say what I'm thinking. Heather is a beauty. Pierogi is a hero scammer hacker. Oh, okay. I thought it was like a potato dumpling. We're on real time, Chewbacca. We're fast forwarded as much as we can. Would you like to get a look at, would you like to see Chaka? Because we're in the land of the lost right now. And Chaka is our leader. I think our audience might be skewing a little bit younger because a lot of people don't know about Chaka and the land of the lost. Ryan's testimony helped the defense too. I agree. She's a beauty. She's one in a million. Who sings that one? I know. I think in song lyrics. That wink and nod says, "Sure thing, Brennan." I remember going over that with you as we rehearsed. It's like, say no more. Your wife, is she a goer, eh? Is she a goer? Say no more. Say no more. It was the tubes? Thank you. Thanks, kindergarten cop. Ham Sandwich says the sad truth about corruption and familial alliances is 10 to 20 miles in any direction in Massachusetts. And this situation could be similar with opposite outcomes, just the way Massachusetts is. Thank you for your 10 and for your insider knowledge. Cannoni's disproportionate disdain. Oh, this is the same one that I was confused about before. Can you please add Rick James' song "Bustin' Out" to the Spotify playlist? Fits the defense, Karen Retrial too. Thank you. Thank you, Tall Glass, for your super chat. I sent you a message about how Paul O'Keefe was moved because he was making faces at Karen, according to a news source. Did you send me the link to the news source? Because I didn't see it. I got 700 emails yesterday, but I'll take a look. Thank you. Appreciate you. Aaron, the feds move slowly or not at all to build a strong enough case to maintain their 99.1% conviction rate. If they're not sure, they don't pursue it, right? But there's nothing that indicates to me that this, whatever they were investigating, has been closed. Melissa says, Mel, will the defense be able to have Dr. Russell review the Emmys report? Sure. She's ultra overqualified and was his employed to do this. What are your thoughts? I'm so keen to watching her stand her ground. Me too. I can't wait for Dr. Russell. I don't know if she's allowed to talk about the
You've
cause of
explained
death.
to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on
You'll
the
have to
question.
Let's
specify.
work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the scientific working group digital evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
Yes, approach. Don't let her give her opinion.
On this issue, okay?
Oh, I'm sorry. This is the last time I'm going to see you on this issue. Is that a stern, grave concern warning, Judge? Listen to that.
It's the last time, Mr. Alessi, on this issue, okay?
This is the last time, Mr. Alessi, on this issue. He's trying to say her methodology is crap, and she's not qualified to render an opinion. And he's entitled to do that when he's got a client who's facing life in prison with possibility of parole after something like 15 years, maybe, if she's lucky. But she's annoyed. Under her eye, we have sigh emojis for her. And we are back on real time. Yes, Jade, Turtle Boy did an experiment with his Lexus, and he was scared to go any faster than 19 miles an hour. He felt out of control and even jumped the curb on one try, right? Imagine trying to do that with a light dusting of snow when the roads are real slick. And that's crazy. Beyond the Crime, Stephanie says, on the road to 100K. Smash the like button, friends. Congratulations, Melanie. Oh, thank you. Thank you so much for your compliment, Stephanie. I appreciate you. Thank you, Sue, who says, I often think the same thing that she's thinking. Thank you for your super chat. Catbox says, Apple iOS users go to settings, apps, Safari, click request desktop site, open Safari, go to YouTube channel, join button will appear, affects all sites. That's so interesting. Yeah, I guess because YouTube is owned by Google. Thank you. I'm going to save that in case anybody else needs the answer in the future. Thanks. Katrin says, I'm watching for the first time and my jaw is literally dropping. Previously, I knew only the name of Karen Reed, but I'm convinced in her innocence. See? Thank you for having common sense and for being interested in this enough to watch it from across the pond. Has anyone filed a claim against Karen Reed's car insurance? Well, that's interesting. Just us for John O'Keefe. The O'Keefes have filed a wrongful death lawsuit, but just recently, only after the last trial ended in a mistrial, right before. No, they had time on the statute of limitations, so I don't remember when it was filed. I want to say like last fall. It's a wrongful death civil suit against Karen Reed, C.F. McCarthy's, and the Waterfall for over-serving Karen and for the car accident. Nobody ever filed an insurance claim, as far as I know, before that, like a no-fault claim for the medical bills of John O'Keefe, because there was never a crash report filled out by anyone at MSP. And you must be an insurance adjuster, because I've been screaming about that for a very, very long time. All the claims adjusters that are in the chat or that have worked for insurance companies have said we would never pay on this as a car accident. Another reason why they might not have wanted to do that is because insurance companies have excellent investigators, and they would have came in and they would have done their own investigation that would have shown that this was not a car accident. Perhaps nobody wanted them in there. Thank you for the excellent question. Type 1 Mobile Detailing says, I haven't been able to follow along like I did on the first trial, is what I think you meant to say, but you wrote forest trips. How's things looking for our girl? Well, every witness the Commonwealth has called so far, I think, has been helpful to the defense. Depends on who you ask, I guess. Come back to the light. Thanks for your super chat.
Ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2/27/40 was, whether or not that was the time the search "How's long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, How's Long to Die in the Cold, occurred at 2:27:40 a.m. on January 29th, 2022.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have a?
She can't say that it wasn't also searched at 2:27. Are you picking up what she's laying down? Listen to that again. Listen to that. She's not going to ruin her career over this case. Listen.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
It could have also been searched at
Do you have
2:27.
an opinion to a degree of scientific certainty
Right?
whether there was any other searches similar to How's Long to Die in the Cold that evening on that tab?
I'm going to allow it.
May I first inquire, you meant morning?
She's not
as
saying
I
it
said?
wasn't
That
searched
morning,
at
yes.
2:27. Do you
Just
see the
clarifying,
difference?
I did not look at evening searches. And can you repeat? I apologize. I disrupted my own
Do
train
you
of
have an
thought.
opinion to a
She's
reasonable
freaking out.
degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, How's Long to Die in Cold?
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Oh,
Did you develop a chalk that I
I
showed you
did.
earlier?
Yes.
Like to approach?
not accurate.
Yes.
Lori M coming in with the T. That is a separate and distinct artifact. Both 2:27
Again,
and 6:24 a.m. had matching
Same
terms.
document, you recognize it?
6:23
Yes.
did not match.
What
All
is it?
three searches have
It
their own
is
timestamps.
the
She can't
exhibit that I
say
created that was labeled
it
Table
wasn't
1
made at
in the first report
2:27.
I delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move subject to redaction that this be introduced into evidence.
all she said is the final one was at
Your Honor, I have
6:24.
no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe. Mr.
Thank you, Your
President.
Honor. Appreciate it.
And ruining her career, Kim. Nobody will ever hire her again.
Madam Clerk, 82.
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay,
She was only given them a PDF. That was it.
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari
I'll full screen this for
related
you.
to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term How's Long to Die in Cold, with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. and it provides artifact to cache record.
Mhm.
It's
What
cache,
is the term,
moron.
and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 623:49, we have a cache record that indicates that Apple suggested the phrase, "How long does it take to digest food?"
And then under that, 623:51, it appears it says a recent web search, and the spelling is changed. How long? TIDIE.
Okay.
INCIKD.
Stop.
So-
Why would the suggested term come up before the 623 and 624 search? I'm no forensics expert, but that's sus to me. Why would why would the suggested term come up before the 623 and 624 searches? Because that's what it says. I don't know, but that's what this little chart says.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person
And it goes
inputting
backwards in
into the phone
time?
at that time continued to type out a phrase and finished it as "how long?" TIDINCIKD.
No.
Which that is available.
So we're going back in time now? Okay, now you've lost everyone. Now you've lost everyone.
Available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line.
No.
So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge.
Yeah,
It's
it
an easy
holds
way
your
to remember
knowledge
it.
from
That's what I teach my students.
227.
So that
It held your knowledge from 227 when you searched it for the first time. If you started typing in how long to DI, it might come up how long to digest food. I could see that being, a suggested search, because how long to die in cold is probably now a very common search term, but it wasn't then because of the 227 search. Thank you, Jeanette Marie RN.
that Knowledge CDB tracks a lot of
Happy
things for
Nurses
predictive
Week.
purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
Oh,
So
Chaka,
one
you're
search
blocking.
can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or
Chaka block.
artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see how long to die in cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
How can she say
As
whether it's a
mentioned before,
coincidence?
through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C. Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made.
Objection, Your Honor.
To a reasonable degree of certainty, I can say that Hoslong to Die in Cold was searched at approximately 6:24 a.m.
But you can't say whether it
Moving
was
on
searched
from the 227 search. There are two other issues.
in addition to
that you were
227.
asked
She
to
can't say that it
analyze.
was,
We talked
she
about
can't
it.
say that it wasn't searched at 227. That's what I'm getting from her. But she can say it was searched at 6:23, right? Because she remembered in the morning that she Googled that in the middle of the night. She was like, holy crap, now I have to go back and spell it the same way so that I can say Karen told me to say it, told me to Google it. And if Karen told you to Google hypothermia, why wouldn't you just Google hypothermia? It's not hard to spell and it's less words, right? Make it make sense. I can't.
At the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, how long to die in cold, was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version and the version in use here uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're
No,
ordering
we
food.
would never
our
be at a
table is the
restaurant
table.
together.
Data is
Sorry.
going to come to the table, and that's going to be our food.
I'm sorry.
So
We
when
just
we
wouldn't.
order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza.
I want a steak. A filet mignon would be nice.
Another
Thank you.
table orders
Au poivre or Bernaise? What do you guys
waffles
like
and
better?
pancakes. They
Or
think it's
gorgonzola
breakfast. The
cream
waffles
sauce
and
is good, too.
pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion.
No, they spit on it. They take the pepperoni off and they serve it back to you. It's not a deletion. It's recycled. Come on, girl. You ever work in a restaurant?
Pepperoni pizza was just removed from the table, right? We're deleting it. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until
Pepperoni is
the
entered the chat.
database is closed, and then when it's reopened, all those changes are made.
Any
both
pepperoni? Who's got
additions and
pepperoni on their bingo
deletions.
card today?
So often when a phone is imaged, when we make a forensic image, the applications are still.
What if there was another pepperoni pizza that was back in the kitchen that was sitting on the, whatever you called it, the warming station or whatever, since 227? What if there was another pepperoni pizza that had been there since 227, and then somebody made a fresh pepperoni pizza and sent that one out at 624 because the one that they sent out at 623 didn't have the pepperoni on it? What about that? What about that?
Still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So when we parse the data, and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet.
They're cold by now.
So when we
gotta make
get
them
the
again.
data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleted and food or data that hasn't yet been delivered
All
to
I
the
know
database.
is you're getting a really
So
bad
the wall
tip
file
after
consists
this
of
meal.
both.
I'm stiffing you.
So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International
Congratulations.
actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We
We can't
refer to
recover
things in
from
statement
this. We
of
can't
recovery
wake up
because we need to
recover.
determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file
Is there a
elements
carving
such as the
station at
search
this
for
restaurant?
the
Because
YouTube
maybe we
video,
prefer
It's
the
Raining
carving
Men.
station. I think now it's time for the carving station. Maybe a little prime rib. I don't know, even flank steak at this point, some kind of meat.
Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in
You can
the
delete the
interface.
search.
So it could not be deleted by a user through the interface for that most basic reason.
Waffles,
So
pancakes,
a
pepperoni
user,
pizza.
could they delete a tab if they wanted to?
There's no actual option to delete
Nobody
a tab.
deleted the
For your web
tab.
history, you could clear the cache.
You can delete the search. Nobody cares if she deleted a tab. Does she have a mute button? I mean, we don't look at that was a great screen. That was a great freeze frame too.
No actual option to delete a tab. For your web history, you could clear the cache.
Oh, there it is. Clear the cache. He calls it cache, which is something he has none of, by the way. He's got no cache.
For example,
Nobody's accusing her of
most of us
deleting
are
it.
familiar of clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X. which means that it is recovered. Axiom indicates that it is carved. In the same paper
Back to the
that I
carving
referenced
station.
earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
An examiner should never assume something's deleted without doing a manual examination.
You know who else shouldn't
manual-
assume? Investigators investigating a possible crime scene or a possible murder. They shouldn't assume either. But you should hear about the guy we heard testify yesterday and the day before. His name's Gallagher. He's an absolute moron, and he assumed everything and nothing all at the same time. It was like nothing I've ever seen. It's strained credulity. But she says even in her job, she should never assume. That would be really bad, really bad. And she's not even trying to catch killers.
in Celebrite or carved in Axiom, should
An examiner should never assume something's deleted
Never
without doing a
assume.
manual examination.
the
of the
manual
phone?
examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the
She got a
data set
PDF.
generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's has long to die in cold. Sorry, trying to
That
clarify.
was
Pardon
deleted.
me. Did you come to an opinion to a reasonable degree of
Oh.
scientific certainty
No,
whether
she has an
any
opinion.
user deleted the phrase, how long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the
I
phone?
analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in
Maybe
the
to you.
forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular
SOS.
calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing.
Oh, sneaky.
The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time.
Well, that would be
on
important, wouldn't
the
it, Meg?
29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day
Biomes have
on
entered the
January
chat.
29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all on call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In
She didn't
manual
have the
analysis
phone.
of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have
It
no
would
further questions.
it would delete the most
All right.
recent, not the earliest call. Does that make sense to anyone?
I see counsel at sidebar regarding scheduling and a few things.
Scheduling. Isn't she coming back for cross this afternoon for the barbecue skewering? That's going to happen to her after lunch. I mean, it's 12:52. Well, we'll wait. We'll wait. If somebody could carve out the most important parts of her testimony for me, I would appreciate it. But to me, she said she can definitely say that the 623 search happened, but she can't say that the 227 search did not happen. That's really what I picked up from her laying down. So Paisley Chicken said maybe this was going back to Connor Keefe. Maybe his first autopsy was Sandra Birchmore. Pure speculation. That would be crazy. John O'Keefe's missing sock says my full name.
Ms. Hyde, I'm going to let the jurors have lunch. You can walk out after the course of lunch.
Thank you, Your Honor.
45 minutes.
Thank you, Your
Jurors
Honor.
will recess for 45 minutes for lunch.
All rise for the court, please.
We'll see if
Here's
they-
the notebooks, follow me.
Have anything more to discuss. I'll just mute it for a second. My full name is now the ghost of John O'Keefe's missing socks. Well done. Thank you for your super chat. Maria said, do you think John sealed his fate when he asked Chris if Kevin will be there? No Birchmore mentioned by the judge makes me think it's all related. I didn't even think about that. Maria. He asked Chris if Kevin would be there. Did he ask him that when he went to D&E that day, or did he ask him that some other time? I mean, I see the way you're thinking. I don't know. I cannot confirm or deny. Bits and Pieces by Dave Clark 5. Thanks, Dennis the Menace. I had a feeling that was on there, but I'll check. Tammy, aloha to Hawaii. I love Hawaii. Appreciate you too. Bear hugs to Karen and her ohana. Thank you. Tracy, Karen would have also been injured had she backed into John at a speed of 24 miles an hour. Never happened. Thank you, Tracy. Another great point. She absolutely would have been. Never, never. Jameson and ginger glass. Didn't Higgins say he left because all they had was beer? Yes, they did not have whiskey, and so he had to leave. And he had to go back to the Canton PD and move some cars around. And he also claimed that he didn't make any phone calls that early morning, only butt dials. And yet, some mysterious Sallyport video surfaced after the trial was over, showing Higgins talking on the phone outside the Canton PD Sallyport. Because you know why? Because you just can't make this up. It's like a bad dream that we can't wake up from. Pro Gamer said that Turtle Boy has just been assaulted by Farris in front of CF McCarthy's today, like now. Cops, TV crews are all there. I'm nervous for him. When was this? 11:23. That could be a troller. I don't know. I have no idea if that's true or not. People try and get in here and they try and put things in here just to rile people up that aren't true. And I really don't know if that's true. So Kathleen, jury could consider, was John O'Keefe bent over an SUV hit him in the face? I'm just wondering, not saying Karen Reed hit him, but he would have facial injuries and he would have massive other bodily injuries that he does not have. It would be impossible to, if he was bent over, for a car to just hit him in the head and not injure any other part of his body. Physics makes it impossible. Merch idea, outraged and appalled because we are. Thank you, Rose. I'll take it under advisement. On top, that's not really, we weren't disparaging the witnesses' looks, aside from Lally's baby shark hairdo. And whoever said that I only make fun of, that I allow making fun of men and not women. Or whatever. I don't know. I didn't let people talk about Jen McCabe's tooth. So there's that. Shay, the trial will be the death of me. The fix is in. Shay, people feel you. Turtle Boy's fine. Okay, I don't know how that got in there or why. I guess it's another troll. They're sneaking in, but they're waiting 48 hours to come in. Comment, so that's kind of funny. Can Alessi just ask if she had other testimony with the same methodology and get it in organically? That's what I think he was trying to get. That's what his objections were about, the methodology. And so we'll see. Somebody posted like bits and pieces of that decision from Maryland, but it's like, it seems to be more than 6 pages and there's only like little half screenshots of pages that were posted and somebody sent it to me, but it's only like 2 pages of the whole decision. So that doesn't really help me. I would need to see the entire decision before I could even read it to you or opine on it. So there's that. Just Irish Haas, many company plugs. Will she sneak in? I don't know. Melanie, come back. Thanks, Lisa. I had to go fill up my drink. How dare you? Says, I've been reading the captions. They have mentioned quoted statements in notebooks as well as culture counsel married to TVD for identification. What the dog? Yeah, it's closed captions are always wrong, but that's how we got motions in Lemonade. So we got that going for us. All right. So I'm going to imagine that they're coming back at 1:45 and we are just going to take that off because I said so. Karen Reed's not guilty verdict. One theory I heard is that Brennan is helping the feds keep Karen out of jail while helping them bring down Morrissey. Thoughts? Yeah, I doubt it. I mean, sometimes I wonder if he's not blowing it on purpose myself. No, I think there's a lot of rumor and speculation out there. I try and stay away from it. I'm a lawyer. I'm a legal-based channel. Show me the documents. Show me the police reports. Show me the testimony. Outside of that, I don't get involved in the drama and things such as like that. But I do have to take this call, so hang on for 1 second. All right, I'm back. Hold on. Aggressive carpet. It says, so the defense cannot waste time and resources showing this lady is unreliable, but Brennan can waste hours and resources protecting Jen McCabe. It was like this the first time too, right? JBG says, I was listening to Allie McCabe's first testimony. She clearly says John O'Keefe was at Albert's. I missed it, but she said Colin wasn't there when John O'Keefe was. Yeah. And then she started to cry and then she panicked. And yes, We picked up on that as well. I don't know if she's testifying this time. I don't think the Commonwealth is going to call her. Grace says mobile app device and consultant here. Hey, worked for Google. PDF metadata can be altered. Yeah, of course. Thank you for your expertise. Maria said, Jen also said that Karen Reed was at 34, Fairview at 12:45, but Karen Reed's voicemail puts her at the house at 12:41. Can we address this? Karen Reed's voicemail, Karen Reed's phone connects to the One Meadows Wi-Fi at 12:36. Jennifer McCabe's text messages screw up the new timeline for the Commonwealth because she says she saw the car outside at 12:45 and that was the time of her last text message. The whole thing is blown wide open. And you can hear Karen walking on the garage floor during one of those voicemail messages also. So we know that she was home. Commonwealth is now saying she hit him at 12:31. It's a 10-minute ride from Meadows to Fairview, as Jennifer McCabe also testified. So the whole timeline is blown wide open. I hope that helps. Sidebar, Buffs and Ramsand. As a hungry juror, I am checking out of this expert, blah, 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 blah. Yeah, yada, yada, yada. Thank you, Ice and Fire, for gifting a membership. I appreciate you so much. Slow Ride says that Python is open source, which equals integrity questions. Thank you. Lisa says Alessi will get her. Brina was already lost, and that was at 11:40. Linda Vergata says take it to the limit. Eagles, thanks, Linda. I may be on there, but I'll check. Thank you for your 10. Laura says the case cracker, me in the shower. If you know, you know. Expert architect, just like Tom Brady's destroying his cell phone, plays on the mind of Bostonians. Her headdress is reminiscent of Sarnev's wife. I don't know what that means, but thank you. Luigi, hi. This case is nuts. Keep calm, Alessi got this. Jess is going down. Free Karen Reed. We'll see. We'll see. There's more to come after lunch. Can she explain the forensics for all the butt dials? Yeah, I don't know if maybe Alessi will ask her. Maybe. Thank you, TG from SB. Karen Reed is innocent. 227 Hoslong dying cold happened. Ms. Hyde. That's what it sounded like to me. It sounded like she said it definitely happened at 6:23, but she couldn't say it didn't happen at 2:27. And as we always talk about when we're listening to testimony and we're listening to lawyers talk, what they don't say is just as important as what they do say, right? What do they leave out? Jennifer, so the search for Hoslong dying cold happened before 2:27 a.m. because she said that the tab was already there and then sent to the back, correct? I'm not smart enough to figure that out. I have no idea what she said, to be honest with you, except what I gathered from her testimony is she says it definitely happened at 6:23. She can't say that it didn't happen at 2:27. And it sounded something like that about the tab opening. And if anybody out there like Olivia has broken this down in a way that we can understand it, I'll happily read it to you from their Twitter feed. Yeah, both Commonwealth experts providing reasonable doubt, says Alessi's binder. Much appreciated. That agreed. Agreed. Sandy B, how can they say something is what happened when they don't have the physical phone or the full extraction? That is, he's gonna slice and dice her on cross. Alessi Scissorhands, Sandy B. I have a feeling that's gonna be a big part of it. Long and winding road. Thank you, Denise. Circle of Wills. Since lying is allowed and no neighbors had cameras, can I testify I had a car accident in front of Fairview on January 30th and a Lexus and broke my taillight? I would not. I would not recommend. Michelle, I have 57 tabs open on my phone, some for months. If I search something today, it could look like I searched it months ago. If I use one of those old tabs, I call BS. I know, me too. That's what I'm saying. Like anybody with common sense is gonna be like, yeah, no, that's impossible. Because how are you convicting people on Google searches with timestamps and now saying that it could be months old because it's an old tab? Is that going to be the defense now for any defendant that's convicted on his Google searches, like Brian Walsh? Well, that doesn't really help him. Searching how to dispose of a 120-pound woman's body when you really need to. If it was the day of or months before, you could go to premeditation. I agree. Alex Says, quick question, has anyone from the Commonwealth or defense done the actual force calculations for how strong the supposed strikes of the Lexus would have been impacting John's body, arm, like the Commonwealth suggests? Yes, the ARCA experts have that all covered. They've got it all covered. They are biomechanical engineers. They have such clients as the US government, the Department of Defense, the NHL. They are the guys who like redesigned hockey rinks when people were being boarded, right? And also something to do with the glass. Like they're high end. The federal government paid them something like $250,000 to find out whether John O'Keefe was hit by a car and whether the car hit John O'Keefe. And they said no. And they're going to come in and testify. So you'll hear all about that. Is anyone else picturing Auntie Deb through this entire questioning? Oh, Auntie Deb did do a good impersonation of Jessica Hyde. I totally forgot about that. That's awesome. Barbara Child says, what I care about most is listening to an expert that knows her stuff and is professional. Thank you, Barbara. Melanie R says, can the defense call the ME, Proctor, or any other prior Commonwealth witnesses? If the Commonwealth doesn't, yes, they are all on the combined witness list. They would need to be under subpoena, and I'm sure they have subpoenaed every single one of them just in case. Katina from Canada says, it will never matter when a tab was opened when you conduct a search. The timestamp of the search is when it happened. There's no debate. Sorry, not sorry. Thank you. Thank you, Kay, because we are being gaslit. We're being gaslit. Sorry, I don't remember my lies. Says Alessi has to win this. Of course he will, because there are young jurors who are most likely know about phones and searches, in my opinion. Yeah, and they're sitting there going like, are you, like, I don't think they believe it. I don't know, but I'd like to see who's in court today that's live tweeting from the courtroom about the jurors' reactions. Amy in Arizona says, lost after PDF, but that's all the jurors need to hear. Our review contracts are affirm if a document was sent by PDF, I convert it to Word, red line, and convert it back. There you go. It's possible. Charles says, who would use Google to look for a YouTube clip? Charles is tuning in from South Africa. Thank you, Charles. Amanda, oh yeah, why wouldn't, well, some people don't have the YouTube app on their phone. I know what you're saying. I have the YouTube app on my phone and that's what I use, but maybe some people don't. That's a good point. Amanda, thank you for your super sticker. Jess Machado is there. Thank you. Let's see if Jess has anything to say about the jury and whether or not they were paying attention. We'll get to that in a minute. The 34 correct view says, so Axiom will be used to put people back in jail after Celebrite jailmates are released. Maybe. Maybe. Thanks for your super chat. Cuckoo. B. Apparently our phones can tell the future. Date stamped data with specific searches will be created at the time of the search. Thank you. Thanks for validating me. Abacus flinch. It's unbelievable that Auntie Bev won't let the defense impeach Hyde because it was last minute. Yet when the Commonwealth wants to exclude mention of Birchmore at the last minute, she approves it without a hearing. Yes, you're right. If you weren't watching it here with me and somebody just told you about it, you probably wouldn't believe it. Amanda, thank you for your super sticker. Collusion, not collision. Is it really that complicated? Enter equals timestamp. That's what I thought. You search something, you hit enter, and that's your timestamp. Mimi, in honor of attorney Alessi, release the Kraken from the Clash of the Titans film. Thank you, Mimi. Bev's Hoff Day. Bobby's cross on Hyde is going to be the politest cross ever. I don't know. I think he might be mad. I think he might be mad. I think we might see the Fuhrer in Alessi come out because she didn't let him impeach her. She's not letting him impeach her with that Maryland decision. I don't know. Bev's Hoff Day, Bobby's cross on Alessi. I also tuned out about 30 minutes ago. I'm assuming the jury will be the same. Yeah, unless they're, technology wizards and they find that stuff interesting. Sound, mind, and body. She made sure to get Corn in so they can capitalize on the voicemail Karen left John screaming, pervert. Still no car accident. Thank you. Lunch is, they're coming back at 1:45. I'll put the banner up here. Don't go too far. It's 1:10. Let's see. Where's the banner? PG, when was Tully elected Assistant Norfolk County DA? Yeah, great, right? He's got his hands all over everything, including everything in the Aiden Carney case and the orchestration and going on there. Kevin says, how long was she looking at Cornhub? Octopuppet. As a software developer, the idea that my software wouldn't log accurate timestamps is ludicrous. Thank you. Thank you so much. I appreciate you for helping me keep my sanity today, Josh. So I'm picking up, Jen searched this twice, first at 227, then again after John was found around 624. Now, remember also, his body was on the stretcher. It was on the scoop stretcher at 614 going into the ambulance. So this was like after, I think after John was already en route to the hospital. Were they in the same tab? She searched twice, first at 227, right? Then again, after John was found around 624, 623 and 624. The 623 search had a different spelling than the 624 search, which had the same spelling as the 227 search. I submit to you, Josh, if she did misspell it, as she did in the 623 search, wouldn't the same results come up? Why would she need to type it in twice unless she was trying to match the exact spelling of the 227 search? It doesn't make sense. Hypothermia would still come up in the result, and that's what comes up in the results. I did it the other day. I live searched it right here. Amelia, this is the most unethical, unprofessional, and biased judge I've ever seen. Can't deal with her anymore. Much love to you from Zurich. Oh, Zurich is watching. Thank you, Amelia. Her upspeak is killing me. Only hanging on for scissor hands. Yeah, you know, I was going to mention that too. What I don't like, and it's not a male-female thing, but it's mostly a female thing. And I want to teach all the children out there, especially girls, in STEM. I like to see girls in STEM. I like it. But when you're every question, every statement that you make sounds like a question, it makes you sound unreliable and unsure of yourself. And it's a habit that's really hard to break for a lot of people. Do you know what I'm talking about? It's like when people are trying to tell you something, but it's like, so I went to my friends, and then the other day we had pizza for lunch, and everything sounds like a question. And we got to break that habit. We got to break that habit. I agree. Maria, is anyone wondering why Jen searched how long to digest food? It's an odd thing to go. They're saying it came up as a suggested search. Did he eat at 34 Fairview? I don't know. I don't know, but I think he did say he had like potato skins at one of the bars. I know I can't even imitate it. Right. So true. We got to hit the like button, everyone. Hit the like button. It's free. It's free. People forget. I know. It's kind of like when you come to someone's house, you should wipe your feet off on the mat. It's kind of like that. Just hit the like button because it's free. And so I don't know if he ate there, but they're saying it came up as a suggested search, and that could be true. Proctor's dishonorable discharge from Canada. This is my best at my worst. If you know, you know. Thank you. Melanie R says, I'm still confused why the Commonwealth would hire Whitey Bulger's mobster criminal defense attorney as their special prosecutor when they have multiple DAs. That's not suspicious. I don't know what it is. Well, apparently nobody else in the DA's office wanted to touch it. I call it the hot potato case in Norfolk County. Nobody wanted to touch it. It's called up talking, huh? Thank you, Love Heals. Right. Why? Nobody wanted to touch it. Postmenopausal New Hampshire woman said, I liked it when Dobie ate strawberries. Chloe Albert's revenge is the year I couldn't have been at this trial. I would have already thrown a dozen shoes at Bev and covered Paul O'Keefe's car in craft singles by now and needed better to defend me. Well, he'd have to be admitted pro hoc vice, and you know, Bev denied him once. So there's that. Loudmouse, I love that you say, come back to your phone and see this. I'm gardening and didn't want to miss Squirmy Copper, Winky Eyes. Thank you. Appreciate you, Loudmouse. Thank you to Dragons and Horses for becoming a member, as well as Melanie R becoming a member. Oh, Teresa, thank you for your Venmo. That's very sweet of you. Just says thank you on it. Kathleen just says, oh, just because I'm so sweet. That's very sweet of you. Thank you. David, thank you for your insight and wit. Higgins used to be a dispatcher with the Harvard University Police. He was hated. Really? Was known as a kiss ass to management. I didn't know that. Did anybody else know that? Camille, thank you very much for your Venmo. You're very sweet. Lindsay says, if this was the case on jury duty, Ronald would have figured out that it was fake. Ugh, do I love jury duty so much. Ronald totally would have figured it out, and it wouldn't have been such a great ending. Thank you, Kathleen. Thank you, Heather. Kara says, I'm also a mail carrier and listen to you every day while delivering my route. Oh, that's awesome. Thanks, Kara. Thanks for your service. Colleen says, as I watch your coverage this morning and this Trooper Keefe, I've decided to name the Commonwealth witness Shifty Eyes. I've lost count how many times he looks to Brennan. I know. And is it just the angle that we have, or is it really happening? I'd like to see a different camera angle, but we really can't because the law and crime is like weird. It just shows Karen. Thank you very much, Zudi, for your Venmo. And Catherine says, my son is on a business trip only 35 minutes from the trial. Also, Brennan reminds me of the other father from Coraline. Thank you for thanking me. Heather, I don't really know. I don't really know anything about that. Something about gmu.edu emails. So she worked at George Mason, you're saying? Thank you, Teresa, for your Venmo. Is there anything you guys want to watch for the break? Any content you want to watch that we can put on for you that would let me play it? Laura, I'm so confused by her that my head is in Jersey from Connecticut. We went from internet searches to food. She ain't getting a tip from me. My food is cold. I know, I feel that way, right? Siobhan said, all I know now is that I'm hungry. Jules Ozzy, Free Karen Reed, Cupcakes versus Skullduggery says, waffles and pancakes in my ice cream truck. Cobra Khan says, objection, credibility. Data is plural, but she's using it in the singular tense. Thank you. I don't need a badge says, maybe she did search how long to digest food in case they tried to get the time of death based on stomach contents and not a suggested search. Could be. I'm open to that. I'm open to it. Stephanie says, rubbish. There is a save on search terms for so Hoslong had been entered. It would never have come up at 6:23 a.m. time unless it was done earlier. Thank you, Stephanie. Lady Zelda. Hi, Lady Zelda. Jen searched and deleted, but didn't clear the memory. Another search will reach to the previous search if a memory isn't cleared. Most people don't clear memories in their mobile device. Thank you, Lady Zelda. You know far more than I do about the mobile devices. Steve Woods, server at Google headquarters, record when Haas came in. I don't know. There was some motion for the Google records that went up to the SJC, and I think they did get them. Lunch is over at 1:45. Technically perjury. Dr. Russell equals the GOAT. Says both Wiven and Hyde wasn't given the actual phones. They are basing their analysis on a report made by the Commonwealth, and we all know how reliable they are. Yeah, that's right. PDFs can be manipulated. There is a witness from Google on the list. Thank you for reminding me, Carol. Miss Kitten Cakes, can we please add Hazard by Richard Marks? Perfect for this situation. I wouldn't watch the circus with anyone else. Mel. Oh, thank you, Miss Kitten Cakes. No big whoop. That's a good one. From Canada. Spanky's outmatched intellectually and factually by Scissorhands Alessi. What a joke. What a joke. What a joke. Jill said, why does the top left column say 11:29:22? It says 11 and not 1. That was a good catch, Jules. I didn't see. I'm not watching. We can't watch It's Raining Men because we'll get stricken for music. So there's only certain music that I can play on the show, and can't play I can't play like some Instagram reels and stuff because they have music that's copyrighted, and that is the thing that YouTube hates most. Wolfram wants to know, where's the shoe that he was wearing? A lot of people have that question. Michelle wants Rage Against the Machines, killing in the name of. Thank you. Karen reads not guilty verdict. Once Proctor testifies, the jury will see how rigged the investigation was from the start and will disregard everything this lady had to say. They'll believe 227 happened, in my opinion. Free Karen Reed, love you. Love you more. You mean Arizona? The PowerPoint presentation may have helped the jurors, but I think if used, then Alessi would be able to question the reliability. Thank you. Big Hoss, could Alessi ask if anyone has ever found her not credible, opening the door? No, he would be forbidden from doing that because the judge has made her ruling. And that would be contemptible. I don't think he would do that. Arthur says, if Lexus expert testifies at some point, vehicle parks, front passenger door opens, passenger door closes, car remains parked, Karen waiting, car pulls forward and drives away, never backing up, never doing a 3-point turn. They're saying that they get her backing up and the specific feet and the specific time from whatever new data they got from the Lexus black box. That's what they're saying, the Commonwealth. I think there was a chip on, chip off, wax on, wax off done at some point in the past, but then some Burla invented some new software or something. And now they say they have more data. I'm waiting for it. I'd like to see it too. That's where this whole new theory of 1231 comes in, allegedly. Tammy says, I am a rural male lady in Kansas listening to the trial with you today. Love your channel, listening to the trial with you today. Oh, that's amazing. Thanks, Tammy. Texas Prime. Seems improper, her saying that to Alessi in front of the jury. She couldn't wait until the sidebar. Why would the defense wait to hand over this info about Ms. Hyde? Don't give Bev an out. Maybe they just found it. Maybe it just came to their attention. Because I don't have the first page of this decision, I don't know when it is from. There's a lot of internet sleuths out there who send emails to like the defense team daily, I'm sure. So it may have just been discovered by them. Thank you, Texas Prime. Hubert, no, I was just running late this morning. I'm totally fine. What do you got? You're going to send me some sorts? Yeah, thanks, Hubert. I appreciate that. No, being late makes me crazy, and this trial is making me crazy. But I appreciate you so much. And I was really good at Hubert back in the day. I was really good at Hubert. Cobra Khan, is there any path to accountability for this prosecution judge? Specifically, can the defense team or an external body launch any follow-up? It's not for me to say. It is not for me to say. They've done what they can do legally. They made a motion for her to recuse herself, motion to dismiss the indictments, motion to have the DA recused. None of those motions were granted. Nick Indy, judges have wide judicial discretion. They just do. Immunity. Nick Indy, defense needs to ask, were you given Ian software? Yeah, I think they're buddies, actually. I think she and Ian Whiffen are buddies. And if I recall correctly, you can correct me in the chat. Wasn't it, didn't they get either Hyde through Whiffen or Whiffen through Hyde, one or the other? And I remember somebody testifying that Tully reached out to them, like on their website or through LinkedIn or something. And was like, hey, can you testify for us? Kendra, thank you for your super sticker. Irene, scandalous, mystique, your playlist. Thank you. Love you back. I love you more, Irene. I love you more. Trying to keep missing socks. The persecutors are all about confuse and distract tactics to the jury. All nonsense. I'm so fuming. Not sure I can handle this anymore. I know it's hard. If you got to take a break, you got to take a break. Nothing's more important than your mental health. It's hard. It's hard. It keeps a lot of people up at night. Hyde through Whiffen. So they found Hyde through Whiffen. Maybe that's true. And was it Whiffen that got an email from Tully that said, can you come be our expert? Maybe. BN Trouble 31 prosthetic arm hit video on Taillight. You want to watch that one? He's cool with me playing his stuff because you guys always give him the likes and subs, right? All right. Seymour Doubt says, I can't find the Herrera case. Complete travesty. Bev denied it into evidence, just submitted well, I can't recommend that as attorney, but your version of, yeah, don't put the link. I can't put the link in the chat. As an attorney, it would be completely unethical for me to encourage people to file judicial complaints. Olivia says no, Whiffen through Hyde. So they found Whiffen through Hyde, Olivia. Hi, Olivia. Hello. And also links are blocked in chat and they're also blocked in comments. So people can't drop links to things that could be untoward. Not that that would be, but thank you for your super sticker. I don't remember my lies. Brenda, thank you for yours. Kara, you're so funny. Thanks for all you do. Oh, thank you, Kara. Some days are easier than others. Throw the carved pizza out, says Proctor's dishonorable discharge all the way from Canada. You can tell she doesn't do side work. Oh, Hannah, that's hilarious. She doesn't do side work at the restaurant. If anybody's ever worked in a restaurant, you know what side work is. And you'd probably, we used to have to marry the ketchups. We used to have to marry the ketchups because the Heinz bottles were clear. And if anybody knows about marrying the ketchups, you know about side work. That was the worst job ever. Technically perjury, Mr. Whiffen and Ms. Hyde, Dr. Jekyll and Dr. Hyde. Well done. Thanks, Deborah, for becoming a member. There's no nudists on Turtle Boy because that was fake news. As far as I know. Whoever put that in here before was just trolling. Pierre says this search exists somewhere in the universe. It's just changed form and time is a flat circle. Yeah. Doesn't time drift? Didn't Whiffen tell us that time drifts? Big words for small ideas. Thank you, Cobra Khan. House says this is painful and now I want waffles. Sachet cachet. So say we all. You know. Thank you, Jamie Chambers. It's Herrera versus the state of Maryland. You found a full PDF. Erin, can you want to email it to me? It's fanbase@mlittlelaw.com. Thanks, Erin. Oh, thank you, Lubin Dubin. Lubin Dubin says he hasn't been a member yet, sub yet for 48 hours, but he has a question about the docket. So yes, yesterday there was a motion, Commonwealth's motion to prohibit reference to unrelated death investigation about, it was 686. I went over it yesterday. I timestamped yesterday's video so you can hear me read it and discuss it. But what it was is that Hank Brennan made a motion on the 5th to exclude any reference to the Sandra Birchmore death investigation. It was quickly ruled on the 6th by the judge, and she agreed to not allow them to mention Sandra Birchmore's investigation. And that is why Alessi had no cross yesterday for Garino, who missed 32,000 text messages in the investigation of Sandra Birchmore. The defense didn't even argue it. They didn't even have a chance to put papers on. Maybe they argued it at sidebar. That's probably what happened during one of the sidebars. We didn't hear about it. So she kept it out. Ducks in a better row. Well, that is so well done. What is this sorcery of which she speaks? Ducks in a better row. I love that. Shane, they need to move past this, get to more important evidence the jury won't be confused about and forget. But I'd like to see Scissorhands Alessi slice and dice her. Marrying the ketchups was so boring, Christine, but it was so messy. It was so messy. The ketchup. Olivia, I agree. The judge isn't allowing the defense to impeach anyone. It's ridiculous. She's protecting all of them, right? Because I think she feels like that because she had to let Arca in because she knew there would be an immediate appeal. She'd be overturned and look like a fool. That now it's like she's making up for it. I don't know. It's just the vibe. It's the vibe I'm getting. Midnight Mike says, just give me my freaking cheese pizza at 227. I do not want all your anchovies and olives, please. All right. This may be an unpopular opinion, but who the hell puts pineapple on pizza? I will not allow that. I will not allow it. New York pizza is the best there is. We have a pizzeria on every corner, like a real one, not a sub shop, a pizzeria. Max Bang, ladies and gentlemen, we have just experienced the red solo cup of electronic data forensics. Just saying. Thanks, Max. Musafa's illegitimate son. Whatever phone Jen's got, I don't want it. Never heard of a doctor whose phone that magically self-deletes virtually everything, proving consciousness of guilt. Liz, will the defense be able to talk about her expertise in the Maryland court? Nope. No, they will not. That was argued earlier in the day. People love pineapple on pizza. What? I don't know if we can be friends, you guys. I'm sorry. I'm sorry. I don't know. We are never, ever, ever getting back together. Pineapple and green olives, like together on the same pizza. Who are you? Who are these people? As Jerry Seinfeld would say, who are these people? No pineapple for you. Trisha, right now, if they showed the jury, most would be shoving hot pokers in their eyes. Ugh, painful, I know. Susan says maybe Michael Marcy manipulated the phone. Isn't he a tech guy? Oh, you mean Matt McCabe? Sorry. When I hear MM, I hear Michael Marcy, but you're saying Matt McCabe. Thank you, Susan. That's what people think. People think that. Wiser time. On iPhone Safari, click on search in bar. Here's an option to delete. There's an option to delete, and pages icon leads to bookmarks, reading list, and history with option to delete individual items. Yes. Most people know that. But I'm glad you pointed it out because they're trying to tell us that you can't do it when we all know you actually can do it. Thank you, Wiser Time. Test it out, my friends. Just scroll back to that comment and screenshot it for later. Susan, who ordered her word salad? Not me. Not me. Paul Munn says your commentary here is hilarious. Melanie is making this variable. Something's got to give, Paul. Something's got to give. Something's got to give. I don't know what, but so many people like pineapple on pizza. This is going to cause a big debate. I mean, I was going to do a poll on steak sauces and which you would prefer with your carving station, whether you'd prefer au poivre or béarnaise or gorgonzola cream sauce. Then I was going to toss in like Worcestershire and Peter Luger's just for fun, but they only give us 4 options on YouTube. So thank you, Paul. The pineapple on pizza has me spun. I can't even think straight. They call it, no, I've never tried it. I would never mix pineapple and tomato sauce. Never in a million years. Hannah said she thought she had us on the magic school bus. Yeah, it's the magic school bus. The wheels on the bus go round and round, and Proctor is underneath them. Susan Finnegan, thanks for your 20. Allie McCabe in the first trial stated Colin was not in the house when John was there. Yes, she absolutely 100% did. When she's up to testify, she will change the entire direction of freeing Karen Reed. Justice for Officer Donna Keefe, I don't think they're going to call her. We'll see if she gets back on the stand, Susan, but she did say that. And right after that, her reaction to that is very telling. And she started crying, and I felt bad for her. I did. I felt bad for her. Carmel, thank you for your super sticker. Steph says, damning OMG no calls can be seen before 8:30 on the 29th because she had more than 200 calls between the 29th and the 2nd. Is that what it says? Thank you, Steph. Is that what it means? I mean, more than 200 calls between the 29th and the 2nd, which is why everything got out of the cache. Watching the OnlyFans says, Jen clearly Googled how long to die and cold at 2:27. Then in the morning, she tipped how long, and the phone suggested to digest food to die in CIKD, and then after how long to die in cold. Yes, I that's what I believe. That's my opinion. Thank you for tuning in from across the pond. Dave says, we should believe that John O'Keefe was not in the house because no one saw him there, but was on the lawn despite no one seeing him there. Yes, yes, you got it. You're absolutely 100% correct. Watching the OnlyFans says it makes no sense that she would Google how long to die in cold, then do an other search for how long to die and CIK, right, to suggest how long to digest food, stop wasting time and dismiss charges. Hank, we never will. Never. They're so deep into this that District Attorney Michael Marcy will never, ever, ever dismiss the charges. Never dismiss the charges. Angela says, did she just say McCabe made over 200 calls in 3 days? Yeah, I think that's what somebody just summarized. Yeah. She was a busy beaver. Busy bee. Thank you, Angela. Bo says, I'll listen up when it comes to food and I'm totally lost. I listen up when it comes to food and I'm totally lost. Dr. Jen N, thanks for your 20. Presence of an abrasion surrounding a laceration suggests the direction of the impact, usually wider at the point of impact. Head showed an abrasion above his laceration, so likely impact from higher up, like AJ said. Thank you, Dr. Jen. Thank you, thank you, thank you. Texas Fangirl says Ring of Fire by Johnny Cash. I think I put it on there. Take a look. There's over 100 songs. Over 100 songs on there. I mean, I'll take your guys' super chats, but every time you suggest a song that's already on there, I feel like I don't want you to feel like you're wasting your money. I mean, I'll put your it up there and talk about it, but I don't know how many. It's 9 hours and 29 minutes of music. I don't know where it tells me how many songs are on it. Where does it say? I don't know. Thank you, Texas. Texas tan girl. I need a tan. I feel really pale. Aunt BB says Mel Sue O'Connell is there. Oh, thank you. But do we like her opinion? I mean, do we trust her judgment, Aunt BB? Aunt BB was my first member ever on this channel. We're coming up on our 2-year anniversary. Annie Time says she typed Hoslong at 227, got interrupted, didn't press search. When window pop up at 6 blank blank, she then pressed search. But wouldn't she have wanted to know the results at 2:27 a.m.? I mean, I hear what you're saying, but remember 2:27 a.m. is right after 2:22 when Brian Alberts butt dialed Brian Higgins, and then Brian Higgins butt dialed Brian Albert back, right? So it seems like she needed to know the answer to that, but I'll allow it. Annie, U.S. Marine Corps cowgirl, Semper Fi girl. Is she saying that all digital forensics tools used by law enforcement are unreliable? Yeah, pretty much. Pizza. I don't know if that says pizza. Oh, no, that's a poop emoji. And the only way to get accurate info is to hire her to do a manual exam. Yeah. Yeah, except she didn't examine the phone. So how accurate is it really? I don't remember my lies. Says just FYI, I heard about jurors' reactions when Jen McCabe testified to another law enforcement. When she testified to another law enforcement, one gasp, covered her mouth, and then looked around. NBC 10, Sue O'Connell, she was in the courtroom the first 3 days. Thank you. Allowed says, even though denied the Maryland motion, can Alessi still ask the generic question of, have you ever been denied in a court to testify? I don't think so. I don't think, because there's going to be huge objection. She's made her ruling. So I don't think that would be appropriate. And I don't think he wants to get sanctions. The defense team is already on thin ice. She tried practically everything she could to not only pull the ProHawk status of Jackson and Little and their firm, but also to preclude ARCA. She tried everything. She tried it all. And she realized she couldn't do either. But I don't think that they're going to risk, somebody changed their name to Kim Jong Canone equals keeper to the gates of hell. You're hilarious. Loves a Hawaiian pizza. I am really outnumbered here. John Monagle, why didn't the 623 and 624 searches show as 227? Right. Did Jen keep switching tabs when she did each search? That's a great question. And I don't know the answer. Thank you, John Monagle, for thinking outside the box. We're in a box that we can't get out of. Like whoever it was, Dochi, I think, who was in a box coming out of the hotel to get into the car to go to the Met Gala. And she got really mad at her people for not hiding her costume well enough. Did you see that? Anybody watch the Met Gala or the pictures of the Met Gala? No, I wasn't really a fan of this year's theme. I didn't think that anybody really knew what the theme was. And so I wasn't really so crazy about the outfits. RW, does looking up It's Raining Men count as corn? Yes. Farmer Google is usually listening, hence the suggestions, 100%. And they've always been listening. We're just finding out about the depths of it now. Aloha, Purple Lover. Here she blinded me with science on. Of course, Thomas Dolby. He's on there. One for Dr. Wolf. Yep. You know what? I think I can't remember how it got on there initially, but I think it was a female scientist. She blinded me with science, I think. Thank you. Kimberly, as I drive by my forklift around listening, careful with that forklift. Don't rage forklift. Nobody should be operating heavy equipment while they're listening to this trial. We need like a disclaimer, like it's a medication. As I drive my forklift around listening, did she really say that Jen made 200 plus calls in that time period? I think so. I think she did. I don't think I personally ever called that many people. Well, she was the orchestrator, maybe. Some people think she was the conductor of this whole thing. Talking to a lot of people. And here's another question. If you made 200 calls, but a bunch of them were to the same person, don't they log in as like the same person and it just counts that person's? Or does every single time you called Magic 3 Lucky? Hold on a second. Put this back up here. The closed captions here. Okay, the mic is off because we can't hear it, but there was something here about, look, hold on. Magic 3 Lucky Charm. This is what the closed captions are saying in court. And controllable Volant to Johnson. It's like we're eavesdropping. Is definitely wonderful finale. Is looking at Amazon. I must have DST and remember that because he was being interviewed. The issue you are generally thought it would be. So that's, I don't know, some good finale. Some good finale on Amazon. I won't put one on the desk. What is going on? Kimberly McNeil says, as I drive my forklift around, yes, she did. I don't think I personally ever called that many people. They still have 5 minutes, so I don't know. Weird. It feels like you feel that you're too, and basically you're trying to, I'm reading the captions. It feels like you feel that you're, what? It feels like you feel that you're too, you feel over, you're basically, and you're trying to, so bizarre. John Jackson, can defense use Jen McCabe's 200 calls January to February 2nd? Well, it depends on who she called and what they're used to, and she's already been on the stand, so if they wanted to ask her about it, the time has passed. Why wasn't Keefe crossed? Was he not crossed? He was crossed because a lot of those objections were sustained. They couldn't get him in. He was crossed, right, guys? I've been here for the whole entire day. Are you going to make me go back and look at my notes, al dente? Guys, can you please confirm? Please confirm that Keefe was crossed. He was. Oh, you're listening to Paris Ray in the Crush every day. Thanks, Miss Moser Horizon. I'm sure they appreciate that. Lacey, did McCabe change her time zone manually? That can be done. Hence the suggested search and can't find the deletion. Finally got the super chat nailed 3 times. Did McCabe change her time zone? We don't know. Hence the suggested search and can't find for out the deletion. Don't know. We don't know if she did. That hasn't come up, but it's possible. Siobhan, did she say there was no deleted calls, but didn't they see no calls on her phone and they found on John's? Yes. Yes. But again, this witness was only provided with a PDF. He was crossed. Thank you, Tyler L. She was only provided with a PDF. So really, Alessi's going to shred her, in my opinion, on cross. So we have that to look forward to in the next 2 minutes when they come back, allegedly. Monique Unfiltered. Google searches timestamped when the search was done, not when the tab was originally opened. So if a browser tab was open for hours or days, a search now will be logged in with the current timestamp. GPT. Thank you. I mean, that's what I thought too, but this expert's being paid a lot of money to say something else. Jamie, my friend is the Dedham cop. He thinks Karen Reed is guilty, but knows none of the evidence and didn't watch the trial. Shocker. Blue backs blue no matter what. No, nobody hates a bad cop more than a good cop, Jamie. So I got to disagree with you there. I too back the blue 100%, but not the corrupt ones. Tommy, thanks for becoming a new member. Kathleen had to change her name. Now she's Kathleen R. Eats at Hyde's Diner. Well done. Uncivil wants some waffles. Hey, Kurt. Azaran, Melanie, I saw a site called Giglio Brady List that has Marcy and Brennan listed for misconduct. Any idea if it's a legit site? No, you can't post the link, but there are like user generated lists. And I don't think that's like an official one. I don't know if there is an official one, but I know what you're talking about. And I don't think that that one is legit. I think that's just something created by who knows who. Like you could like Like somebody bought the domain name, and I'm not sure if it's hankbrennan.com, and it routes to like Karen Reed's defense fund. Like, you know what I mean? Charles Argo, all automatics go from park to reverse, then drive. Thank you. Karen Reed's not guilty verdict says if the defense wanted to know which witnesses didn't want to testify from the Commonwealth, I wonder if it was Ally McCabe. Every time I see that, it reminds me of Ally McBeal. Do you guys remember that show, Ally McBeal? I wonder that's why they fought to keep Colin out so she wouldn't have to testify. Don't know. I don't know. But based on all the stuff that came out in the Turtle Boy affidavit, it seems to me like perhaps Jennifer McCabe said to this or the not so confidential informant, Maswell Mafia, told this witness that she, Mafia Maswell, went to lunch with Jen McCabe and Marcy, I think, and that Jen McCabe told Marcy, I'm not testifying unless Turtle Boy's in jail. So that's kind of one of the things we thought about when we saw that, because they happened like in close succession. And Civil has a computer science degree. The stupid burns. Don't get it in your eyes. Side Bob Buffs and Rams fan. Do you think Brennan has any idea that he's losing this case? Is his ego that big? Oh no, I think he's doing. I think he thinks he's doing terrifically, terrifically. But who knows? Trisha. First time watching this trial. Is the judge an elected judge? No, she's appointed. She's appointed. The district attorney, Michael Marcy, is elected, but the judges in Massachusetts are appointed. People have looked into Michael Marcy's contribution lists, and a lot of the troopers are on there. A lot of the employees are on there. Nixon, what Whiffen said about time drifting and clocks is accurate. Don't hang a hat on that part of their testimony. I'm a programmer who works with that. Okay. Right, Nixon. Thank you for telling us. I just feel like my whole life is just drifting by. Like we were lost in a time warp that day. I really don't even know what that means, that time drifts. I really don't. Louise is sleepy, says, why is this being done to defend Jen? We don't know. It's Karen's life on the line. The other witnesses already admitted she didn't hear Karen ask Jen to search for it. Should be up to the jury who to believe. Yes, it should be. Should be. In my opinion, this case never should have been brought. But nobody asked me. They're bringing it again. The jury is the finder of fact. You are correct. Attorneys are coming back. Norman, black box info is from the text stream data. The infotainment center is what they tried the chip off on. Thank you. This would only have GPS data and prove 1162 key cycle happened in Dighton. Thank you. She's talking, but they don't have their volume on.
About something.
No,
Try not.
that was totally me. She's apologizing to the jury for wasting their time. That was totally me.
Conferences that just come to try. I am going to try and keep all sidebar conferences to a minimum, but they're just coming to try. The lawyers not to waste tried. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently, and not to waste anybody's.
Fairly and efficiently, you're doing a great job.
Frustrated at lawyers about something. I try not to, and I don't think I can, but if I seem to cut somebody short, the lawyers are just doing it when they request sidebar conferences.
They must have complained about her.
I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing it.
They must have complained and said, Judge, you're showing a lot of bias when you're cutting me off and acting rude to me in front of the jury. It doesn't look good, Judge. You better give them an instruction because it's getting off the hook now. And she says, I'm going to try and keep sidebar conferences to a minimum. Well, here's the thing, Judge. If you let them say their objection grounds in open court, you wouldn't have to go to sidebar every 5 minutes for your bad rulings because you don't want the world to know that you don't know what you're doing.
All right, go ahead, Mr. Alessi, let's go to the witness.
I just need a witness.
I just need a witness. Can I get a witness? That's on the list. Can I get a witness? Witless.
Your Honor.
Good afternoon.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
She should be afraid. Be very afraid.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Miss McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate
She
you
brought it up.
telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial
Wait,
in the
he's
state
allowed to
of
bring it up?
Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking
Yeah,
about. You have
because
to
she already
move
ruled.
along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the Friends of the Court, you took a position in that quote, Friends of the Court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15.
Page 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top, it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that.
The court reporter can't
I'm just
hear
trying to
him.
move it
Can't get it
along,
out.
but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to
Mhm.
the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct?
Mhm.
You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Can you answer that? Ms. Hyde, can you answer that, yes or no?
Did I read that correctly?
Stop helping.
You read it correctly.
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
If we could, Your Honor, stop
And it will
interrupting
be, thank
and
you.
directing the witness.
And if we could go to slide 82, please.
It's like it's her play and she's directing it. She doesn't get to do that.
And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red. And this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us. He said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you did, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12:20:50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed. And I did not, that is not my report, that's Mr. Whiffen's report. So I cannot speak to that without going back and reviewing that evidence.
isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Melissa, well done. This is what you call an Alessination. I'll allow it. Are you smarter than Alessi? There could be like a game show. Remember, are you smarter than a fifth grader? They didn't give their experts the same info to review, Kelly. You're
If you could
catching
please
on.
turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you could now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis? I
Do you believe that statement is correct or incorrect?
believe that the statement is correct regarding those artifacts that are mentioned in that statement. Yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Here come the sirens.
Can you give me my page number, please?
I will. I'm
Okay,
just.
thank you.
You're welcome.
She's trying to smile, but it ain't easy.
If you could turn to your page 13.
13, Roger.
Roger. No, he's Bobby.
Yes, I'm
but-
there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going. That,
Well, hold
that-
on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but
I believe I know where you're going. Yeah, no, you don't get to do that. He finishes his question and then you answer. You're in court, remember? Have you ever testified before Ms. Hyde? Oh, we know about that Herrera case in Maryland because you brought it up already.
if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
Well, I'll state it again.
I appreciate that.
You're
Seconds
welcome.
count.
So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is
You're not
based
gonna
on
win
your
this
theory
argument.
that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Sure. She's
Isn't
not-
it correct that it isn't my theory when the steps ended?
Oh, it's
If I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other,
Can you
the
imagine being
stenographer's
married
not
to
going
this
to get
woman?
both of us. Thank
Agreed.
you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that,
It's
which
just
just
math.
doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to
More reasonable doubt.
page
Sure.
1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I just center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mhm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better,
Sure.
that 191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately?
I'm doing the math in my head, so that's why I said approximately.
Understood.
But you're a
So
super genius.
am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps
Okay.
taken at 12:21 10 a.m. on January 29, 2022 for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone
Okay.
registered. Very well. Now what I'd like to do is to,
You know, we had Little Miss Can't Be Wrong on the playlist from last trial for Jen McCabe, but now it also applies to this witness. Little Miss Can't Be Wrong.
turn to
He was walking into the house at 12:21, 80 steps.
the phone of Jennifer McCabe.
Ooh, he's going to show how the data lines up.
And that is for
Look
your
at smart.
reports. You don't date your reports, so I can't give you a date, but it
I know,
says
it's report 3, I believe, is what. you're looking at.
exactly.
Yep.
It's 3.
Little Miss Can't Be Wrong.
And there is,
Little Miss, Little Miss, Little Miss.
bear with me,
Can't Be Wrong.
I'm accommodating your page reference, and I'll have it soon for you.
Wafflegate
It is
Insider.
your page 7. And let me know when you are there.
I am there.
No, you're not.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
Called Coco.
I would need to check in my report. May I turn to the page
Yeah, do
for
it.
that
Absolutely.
time?
Do it, because she called Coco at
I
I do
5:07
see
for
an
38
outgoing
seconds.
call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
Oh, why not?
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can,
She really
yes or
wants
no.
to
Is
jump
that correct?
in.
There's no duration yet listed.
Correct.
So what I want to do is
Private info shout out, gifted 20. Thank you and welcome 20 new members. That was super generous. Thanks.
to also note that that omission is not the only omission of durations from this report, or I'll state it differently. Let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call. And you don't start listing durations until 8:59:34 a.m.
Really,
Is
why is
that
that?
correct?
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that, just to keep it simple. I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023, that is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May
Correct.
of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you
Did you get
issued
fired?
more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 2/27/40. Your opinions on what is the meaning of that timestamp have varied from May of 2023
Look at her face.
until today. Is that correct?
When he said your opinions have varied, you need to come back and see her face. But if you're on scaffolding, don't. Or if you're driving, don't. But the rest of you can. Ready? Here we go. Look at her face.
The meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your
Oh, it's getting
May
hot in here.
2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
Oh, Tully.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
Spoke to Tully more than 10 times.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
Tully is everywhere.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words
She said it was deleted.
that Google search, house long to die in cold, was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings,
Mhm.
it starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely.
right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same two searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those two search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right. And I appreciate.
Your task was to say the 227 did not happen. That was your task. Just like Kevin O'Hara of the CERT team was given a list of things to find at his scavenger hunt at 34 Fairview. Here's what you're looking for, guys. A couple of pieces of taillight and a sneaker. Ready, set, go. Her task was to say that 227 didn't happen. Got it? We all clear? Good.
Appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those two timestamps.
Right. So we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay. So we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern local time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant
Typo.
difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern time. So what we would be comparing is 2:27 and 6:23 and 6:24.
I'm sorry, but would anybody agree with me that details matter when you're an expert in forensics and the time of these searches is actually your task? You have one job. And now you're going to apologize because you didn't realize it was in UTC, which is -5. Wow. Let's talk about reasonable doubt, shall we? I can't decide if she's more of a bumbling fool than Gallagher. Maybe we should put up that poll. Who's the biggest bumbling fool so far? Let me work on that.
Be appropriate.
I'm taking nominations.
They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now,
Perfect.
but in this report, there is no UTC time down. You have 2 additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
The UTC was a typo. It should say UTC next to those. And the chart shows all of those artifacts in EST and is clearly
It's not a
labeled that they're all
typo.
in EST.
So you would agree that it's better stated to state it a different
It's not a typo. It's an omission. It's different.
way than you have in.
EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier
No.
for the audience to speak in
Audience.
EST. I would say forensics examiners
One
typically
job.
communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
The defense is relying on your report, ma'am. As is the prosecution, but apparently they didn't pick up your typo because nobody ever had you amend your report. You can't, just when you thought this couldn't get any worse, it gets worse. Just when you thought you couldn't make it up anymore, it gets more made up.
So in terms of your May 2023 report, your first report in this matter,
Yes.
Thank you, Shannon, for gifting 5. You're so sweet.
you on page 5,
Mhm.
in the sentence underneath the block paragraph state, in the instance of the Google search, House long to die in cold that was recovered from the write-ahead log associated with
That's correct.
the X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report.
Mhm.
Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency
Mhm.
with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2/27/40 is unknown,
Mhm.
the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2/27/40 is unknown, correct? I'm just asking, is that what you wrote?
It's a yes or no question.
Unknown.
I believe that the wording here is, sorry. I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27/40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
That was the first trial. Obi-Wan Kenobi. I like that name. Thank you. Thanks, Lisa.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if your honor would like, I will do it, but I'm going to start and then we'll see how it goes.
We'll see what you don't remember. We'll see what you try and deny. Deny till you
So-
die, folks. Deny till you die.
bear with me a moment.
No, pregnant pauses are good. It
Do
gives
you
the witness time to
recall
squirt.
in that testimony stating that you processed the image in several forensic tools? I use Cellebrite Physical Analyzer, and then you list many other tools. You remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I
Fair
spoke to the
enough. I'll get
tools I
that for
used.
you.
I bet she's
May I approach,
wishing.
Your Honor?
I bet she's wishing
Yes,
she had
Mr.
that.
Alessi, you offered a transcript. Do you have the whole
I have
transcript?
the whole transcript of that.
Wish she. I
It
was
might
wishing
speak
she had that
easily.
crappy Zoom camera now with the bad angle, so nobody could see her like face getting red and her getting totally embarrassed and realizing that
Thank
she
you. I appreciate it.
spoke to Tully at least 10 times, who told her to change her damn opinion from May of 2023 because
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan?
is Tully like the big like defender? Is he like like what is going on with Tully?
Okay.
I sure haven't made mention Proctor too much.
Thank you so much. And you said we're on 112?
Yes, please.
Habeas curtains, no iPads collected for Jen McCabe. No.
113, I see it. I see
Gave up her
it's
phone
highlighted
willingly.
on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different table, different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did. That's correct.
And then going up to page 114, line 5,
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis.
What? Why are they buffering? What the hell just happened? They do this sometimes and they jump ahead. We're only a little tiny bit behind. What had happened? Are you kidding? We weren't this far behind. The feed just cut out? Hold on.
Know exactly what caused the tab to get that. The next sentence.
Love of the
Remember, we
Troweling
were
Mary.
just reading. Now let's keep going.
Occurred. That is correct.
Right. So read that
Absolutely.
correctly?
It's specifically pertaining to.
Not one thing.
He's still looking at the transcript.
You state back.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony on line 16. I
You're on break,
have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search "How long to die in cold" in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now, if you turn the page of the testimony
Thanks, Boiled Frog, for your gifting 5. You're awesome. She's trying to be a step ahead of him. It's not going to work.
Back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read
Correct.
that correctly?
You did.
You did. Don't congratulate him like he's a
Not
toddler.
one thing. You said it could be lots of things, correct?
That is correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's
Bam.
specifically pertaining to that particular artifact that give in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mhm.
If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized.
Mhm.
The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130 of your testimony. I need to, yeah.
I'm sorry. Why are you objecting to her testimony? What? It's her testimony. It's sworn to under oath in the prior trial. The first persecution of Karen Reed. In Canada, you call it a Hawaiian pizza. Doesn't a Hawaiian pizza also have like Canadian bacon on it too? Like Hawaiian, it has like pineapple and Canadian bacon. I'm not sure. But since you guys gave me like $10 to try the pineapple pizza, I feel like I'm obligated now. I'm gonna have to get, maybe I'll have to get that for, I don't even know if you know what? I really don't even know if you can get that around here. And I am not ordering Domino's. No way in hell. Scott, do you think any good faith pizzeria here where we live is going to put pineapple on my pizza?
Thank you for your patience.
Think Gino's is
Ms.
doing
Hyde.
that?
Absolutely,
Or
sir.
Mario's?
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're
I'm
absolutely
sorry.
correct. We've been
I'm sorry,
talking about it for several pages. And
I'm
bear
keeping
with
you
me.
too
I
long?
think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database. It was in the write-ahead log. And to Celebrite's credit,
You're talking to me?
that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here, what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On
proceeding.
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and you were
Absolutely.
giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
That could be good, actually.
136, you said?
136, yes.
Thank you.
Grilling the pineapple and candy the bacon.
And on line 12, you note that so Celebrite and magnet axiom,
Mhm.
and then you elaborate both Celebrite physical analyzer, which is a specific tool, right, of
Correct.
Celebrite, and magnet axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That is
correct?
correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold.
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be
a
great.
different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony
Okay.
and let's go to your next report.
Let's talk about that case in
And your
Maryland.
next report is December 2024. Do I
I have
the
it correct.
chronology correct, Ms.
That
Hyde?
is correct.
So in December of 2024,
Mhm.
just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp.
Mhm.
And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report?
Approximately.
Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, magnet forensic axiom showed up, That was removed by Celebrate, correct?
Celebrate no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting,
Yes,
correct?
they did. That is correct.
So law enforcement can't get a hold of it? The clients can't access the timestamps anymore on the phone extractions? But it's still there.
However, your former company, Magnet Forensic Axiom, still shows it.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensic, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes, yes.
She was the director of forensics at Magnet Axiom. Oh, my free game is so on point today. I'm going to use that in the thumbnail. Remind me to come back to this point. That's note to self. Your former employer, Magnet Axiom, where you were the director of forensics, they still have it as 227, right? Oh, babe, I bet you thought you were going to have a better day than today. So you had a bad day. We should put that one on the list about you had a bad day.
But Celebrate doesn't in the automated
That is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Ooh, the discomfort is palpable.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct. Yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report.
Did she
what
not
your
use
report says.
Magnet Axiom?
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report,
Somebody
no
pop in
longer
bubble
shows
wrap?
a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows
One
that,
job. You have
and
one
that's not
job.
what's
That's a
stated.
fair statement. That's a fair statement. Let me rephrase it
Thank
this way.
you.
You're welcome.
Thanks, Becky.
In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes
The
that come
release
out?
notes at the bottom,
Perfect.
right? You
Yep.
referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite's.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure.
For
I'm
sure.
there.
And I'm going to go down all the way down to the conclusion. In that report, is there reference to any company other than Celebrate in this entire report? Is
In
there?
this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now, let's go back to the issue of the extraction of Jen McCabe's phone.
Janine, we're breaking up. I can't do chicken
And
zucchini
what I
pineapple
want to
pizza.
do
No.
is to,
Where are my law students in the chat? Law students, are you here? You are watching a master at work. This is a master cross-examination dismantling her opinion piece by piece, slowly and methodically. He's a master. I wish we could see his face, but we're watching the witness squirm, and somebody said, why is she talking like Snow White? And now I can't unhear it. Thanks, Side Bob Buffs and Rams fan.
cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
Absolutely. No
I'm sorry, Jim keeps coughing during the important parts.
Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
That was a weird gesture.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I referred to that as the MB postulate to shorthand it, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay, thank
I'll
you.
just go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation. We don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this.
She thinks she's smarter than him.
Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily.
How could you say not necessarily?
Because that doesn't perform. Operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing
It's like
and
Gladiator.
checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They
everything.
should not
I'm losing
be
it.
commingled as if they equate to each
A
other.
lot of things shouldn't be
So
commingled.
have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a
I have
question.
not had
Have
that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, already. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances
But
and
not in this
peer-reviewed his
case.
papers.
So you have regard for his
I have regard
reputation?
for his
I'm sorry,
reputation.
we have to wait for each other.
Oh,
to
yes,
talk
I'm
through the
sorry.
trend. It's all right.
So
No
she
worries.
does it again.
So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely,
And you
yes.
believe he has a solid reputation, correct?
Absolutely, that is correct.
He
Now
is
let-
the best customer service rep at the help desk at Celebrate. He's the best. Just like Kevin Albert is the best Canton PD detective. He's the best. Ian Whiffen is the best guy to get on the phone if you need help with Celebrate. He's the best. Great. So you have no reason to doubt his wrong results in this case now, do you? See what he's doing? Setting her up like a bowling pin. Knocked down. Gets to wearing thin. She's ready to jump off that stand.
Let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the history DB of either of those two searches.
Oh,
So I want to
Why not?
just repeat that
I don't know what that means, but
in a different way.
why not?
So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
Why? Tell me why.
You spoke about
And BB, thanks.
PYF PDF on your direct testimony. Do you recall that?
Oh, you
I do.
know it.
It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So
From Cornhub to GitHub, all in one day, my friends.
developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
I'm sorry.
Have you ever
are you
read a
correcting Alessi?
report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if, I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed.
Thank you, Nello.
I did see a report
Tesserino.
in which Mr. Whiffen spoke to the PDF not being signed.
I'll be here all week. She thinks she's smarter.
I'm just try to shortcut this
than
and
Alessi.
work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF.
Can't
I would
you
need to see
see?
the report,
Can't you
especially since
see
the characterization
what
of
this
hash value
woman
being unsigned is not a term of
doing
art
me?
that I am familiar with in our field.
Can't you
Let me
see?
ask if you agree or disagree with this statement.
Marshall Tucker Band.
This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with
His
that
statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone?
The history of the
It's a
extraction.
yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
Oh, I
In
love
an
this so much.
extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation
She's a talker.
as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the
I love
device.
this. He's going to let her go.
This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger, just like when your battery runs low, you plug in a
Stop
charger
looking
in
at
the
the
back
jury.
of these
You
battery
lost
packs.
them a
We
long
do
time
that
ago,
with that
babe.
before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device.
Oh,
This is
you know,
so
that it's so funny that you brought that up because a lot of people are wondering whether John O'Keefe's phone was put in a Faraday bag between, I don't know, 12 something and 6 something a.m. You know, that period of time Whiffen talked about where nothing happened with the phone. So interesting you brought up Faraday bags.
remote wipe command
Here's
couldn't
what a Faraday bag does. Listen to her telling you what a Faraday bag does. This is so perfect.
with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data.
Unless
So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The
So many
next steps
things
are
you
going to
don't know.
depend on what state that device is and what make and model that device is and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So
Mm-hmm.
what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or
Nobody
aware
told
of.
you?
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear. I don't know when, I don't have information outside of the digital forensics realm about this case. So I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe
She's telling them
was
everything.
deceased
I love it.
around the latest 9 a.m. on January 20.
Hold on. Back.
O'Keefe.
Okay, assume that.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Thank you, Your Honor.
Ma'am, Your Honor.
So
I would love to see Brennan and
bear with me. It's a big
Lowry's
report, as you know.
faces right now.
It's a big report.
It's a big report. She did a lot of work on this. Do you charge by the page?
And it
or
was
by
at the bottom
hour?
of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find
Nervous
it. All right,
chit chat.
so
Your Honor, may I assist and point her to a page?
that'd be
Thank
great.
you. If you could turn to that report on your page
So big.
47
Mhm.
and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So,
Notifications from Ring. Notifications from Ring. Tell us more about that.
was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what.
So did anybody delete any Ring videos from his phone after he was at the Endless Heaven buffet, as Kathy would say?
You just had me reviewing the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you
It
tell
is.
me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? or
No,
not?
you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice
That-
would be to Faraday.
that
I
wasn't my
100%
question.
agree.
My
Faraday
question
is
wasn't
now a
is there
verb.
more or less data. My
To
question
Faraday.
was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond
There
that.
could have been
Right,
more.
but as far as your scope goes, I want to be clear.
Yep.
There is activity on
Absolutely.
this phone,
Absolutely. The
which
phone,
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
correct. It is not in accordance
Thank
with
you.
the best practices. I agree. I would have Faradayed it.
Oh,
Thank you.
thanks. Thank you.
So
If I,
that's
presuming all
okay.
things.
I have
talking.
no
Keep talking.
further questions. Thank you for answering my questions. Ms.
Wow.
Hyde.
Thank you for your questions.
Thank you
Have a
for
great
your
day.
helpful testimony. I don't even think Brennan knows what to do at this point. He's like, yeah, can I have a 3-hour break until tomorrow? Because I have no idea what just happened. And I need to consult with, I don't know, Tully. Oh, look at him standing away. He won't even go near Alessi. He won't even cross his path. What was that guy saying yesterday about the snow? There was enough snow to track a cat. That was a thing of beauty.
Of course.
He's shook. He is shooketh. Is he shooketh or is it just me? He's shooketh. Mic drop.
Whenever you're ready.
Thank you, Mr. Gray.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this,
It's easy to remember because May the 4th be with you. Stop it. She did not just say that. Did you see the court officer and the people right next to Brennan start laughing? You know, guys, we did a show on May 4th and I have never heard that before. And you guys, I was like, oh, tomorrow's Cinco de Mayo. And you're like, and everyone's like, oh, May the 4th be with you. And I'm not a Star Wars person. She did just say that. And now we know she's a Star Wars person. And this is comedy gold. SNL writers. If you are, I don't know who's on the show this Saturday. You may be on hiatus. I don't even know. But if you do not take advantage of this, or if Auntie Deb is out there, I know Auntie Deb is out there. May the 4th be with you. Listen, this is, watch the gallery. I'm going to take the captions and put them here, but watch that court
On
officer's face.
analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023,
Obi-Wan,
what
are you
was
out?
the catalyst for you to begin working on this?
R2-D2. That's really all I know from Star Wars.
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those 2 search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you would have focused
Now
on?
I know.
I was to focus on the 2 search terms from January 29th, 2022.
And when you informed why, was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those 2 searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion
Hank Solo.
that the 227
Okay, I have
timestamp?
to. Ashley Lauren, the highway, the LIE said Sith happens, drive safe. And the northern state said something like Han Solo, something, something. And I was so confused. And now I get it. Thank you. Somebody said all nerds know that May 4th is, wow. I don't even know what to say at this point. Hank Solo, I'll allow it.
To provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No,
When you engaged in your analysis, was it independent of the district attorney's office?
my analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No,
Would you ever allow anybody to affect your input?
no.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes,
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
the scope of that report, may I review what I have documented as the
Please.
scope?
Luke, I am your father.
I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
Who's
And
Chewbacca
I have
and all?
the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That
I just want to hear that again because is she talking about her scope of work right now? So hang on, because I got so sidetracked by the Star Wars conversation.
2, that's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
That was her scope of work. That is what she was tasked with.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Just gone.
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrite actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing
In the Karen
the
Reed
meaning
case.
of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Distort?
Can I read Celebrite's own statement?
Please.
No.
Celebrite's statement
No, to yourself.
to myself? Okay, roger that. Thank you.
Roger
I
that.
appreciate that.
R2D2. Luke, I am your father. Remember Carrie Fisher with the I mean, I do remember Star Wars from like the first one with Carrie Fisher.
Can you
Could
repeat the
share with
question
us,
now?
was there
Buns on
any
her head.
reason other than the concern about misinterpreting or
Yeah,
They said
distorting?
that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about,
That it's not a reliable timestamp. They did have lunch. We're coming up on the end of day here.
Can you
could
repeat the
share with
question
us,
now?
was there any reason other than the concern about misinterpreting or
They
distorting?
said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrite Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrite before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrite give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide. And that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release notes. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
I think Ian Within
Is there
wrote a
any
blog.
releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have O'Keefe's phone that night or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you
Thank you, Mama.
analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag. So usually those phones would not
Sometimes
be
they do.
Faradayed,
You know
but
who
they
does
would
that?
typically have airplane mode enabled.
The
Or
mob
SIM
chops
card
off the
removed.
finger. I've
But
seen
the SIM
that.
card remove doesn't actually work on iOS, so I won't get into
Criminal
that.
Minds, maybe?
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr.
I mean, you could
O'Keefe's phone?
try.
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
Here's Don Chichio's rendering of Jessica Hyde.
You were asked a very specific question to die in cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about how long to die in cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts.
Make him say that.
That demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari PLIS, which tracks the history, as well as the Knowledge CDB. So we do have
Make him say
2
it.
artifacts showing that those searches were done at that time. Of course, 6 seconds apart for
He
the
says
difference between the
corroborate.
Knowledge
Make him say
C
it.
and the Mobile Safari PLIS.
You did hear it come at me. You heard it.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow up.
Oh,
You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data. for
it's not
July-
healthcare data.
I'm sorry, January 29,
correct him.
2022,
That is correct.
page 6 of your
California
report.
screaming.
Thank you.
It's not healthcare data. Is she going to correct him the way
You
she corrected
noted
Alessi?
that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether
data.
steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device.
Going up
So
a hill in
it
your car
could
and
be
waving it
steps.
around?
It could be you're carrying it. It could be that you're in some other kind of motion. You could be on
Bullshit.
a bicycle. You could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps,
Now
but
you're an expert on
it is
Apple
possible for
healthcare
other things
data.
to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
From Ms.
Your Honor.
Yeah, this is outside the scope of anything.
I'm going to deny that question.
Oh, she's denying something.
Can these health
Oh, wait.
steps occur if somebody's holding a phone
She
while
denied.
traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical. You could be in a vehicle. You could be on a bicycle.
What?
It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's
You could be in a
phone
car?
and the report that was pointed out to you on cross-examination, and do you have information or opinion where Mr.
Where's
O'Keefe's
the
phone
view?
was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope.
Scope. May the farce be with you. Thank you, Michael McLean.
It was
Excellent.
pointed out to you at 12:21:10, there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12:31:56 for 20 seconds.
That's correct. Per the
And-
data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at
That's correct.
12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyze the phone and were
After
asked
he was
about these times,
incapacitated by
is
her
there
car.
any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
Because it was in a
I do
Faraday
not have
bag
anything supporting that in my report.
before it was in
Do you
police
know what
custody.
was going on with Mr. O'Keefe's phone at 6:04:01 a.m.
Bobby,
on the morning of
could it have
January
been in a
29,
Faraday bag?
2022?
I do not know precisely what was happening with his phone at that time in terms of movement, if that's, or are you asking me?
Faraday bag.
I'm sorry, can you clarify what you,
I really don't want to
Yes,
script
by
the
the
case any more
question.
than I already have.
The next movement after 12:32:16
is the
is
6:04?
6:04:01
Correct,
a.m.
correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't, that wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on
It
a rail
wasn't me.
car. I don't think
Shaggy
it was on a rail
defense. It
car
wasn't me.
for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr. Lee?
Oh, please. Hold on. We're not done with the skewering yet. The barbecue is nowhere near over.
We have a moment here.
Take all the moments where I love you behind because we had so much fun with that.
Beyond stating that their opinion was the 220, do you recall Ms. Hyde?
We have WD-40 emoji for that.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes,
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the,
thank you, I appreciate it.
Wait for the
and I'll
support.
repeat the question.
Thank you.
That's a long one. Wow. 80 steps to John O'Keefe. Yep. It's a lot of support from Dedham Fire Department today. Ask me how I know.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm
published,
sorry, my
but
question
not
is, do they
Celebrite?
state in the release note whether there's
Press
a
release.
reason for why they concluded?
Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
Thank you, Strong Leg.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank you.
Absolutely. You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there is further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is-
unreliable.
Move on to Axiom.
Mhm.
You were asked questions by Attorney Brennan and you referred to Axiom as using a different parlance of with the timestamp of carved, correct?
Celebrate uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
it's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example
Thank you,
of
Bias Bet, for your 20.
maybe
You're right.
needing to use a biometric to unlock a phone. And that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live.
Thank you, Kathy.
But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6
and
a.m. to
I'm-
noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But
Like
it does
everything
not
else in
appear
their
to have been
department was
placed in
failing?
Faraday
How-
bag.
All right.
No, I'm
I'll-
just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but
Wow.
in
she
100%,
really
it
loves
appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless
great witness
biometrics
for
were
the
needed.
defense.
So
Great witness
let's
for the
now go
defense.
to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto deleted, if that exceeded 200?
My question is, do you know whether there was auto deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto deletions. Because I
about
don't know
deletions?
what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because
I'm going to let this play, but I have to run to the bus stop. So I will be back to go over questions. I'm going to let this keep playing though. Don't worry about me. I will be right back. Okay. Bus stop time.
more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again? I
Absolutely.
apologize. There's
Oh, no.
a lot of timestamps going back and
Please
forth.
do.
12/31/56, is that
Yeah, that's the start. Yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes,
Thank you. Appreciate again you answering my questions.
thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
Or I see counsel about scheduling. First, feel free to stand up and stretch.
May I?
Yes.
I would like to play clip 15, please.
A little bit more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Okay. All right, so folks, I talked to the lawyers briefly about scheduling at sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So We're on schedule, ahead of schedule. We'll reevaluate that tomorrow. Now you will see the lawyers and sidebar as we do as well about talk a little bit about scheduling. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with the decision you use. We'll see you tomorrow morning. Thank you.
All rise for the court, please. Closing notebooks to follow me.
Why don't you come on up?
Hey guys, I'm stuck at the bus stop. I don't even know if you can hear me because I don't know how to use this from my phone. But I'm going to end the stream for today, and then we'll come back tomorrow and we'll take on any more questions that we didn't get to cover today. So I will see all of you guys in the morning. I don't know if this is working or if you can even hear me, but hopefully you can. All right. Peace out, everyone. I'll see you in the morning. How do I end it?